From prestige TV to reality shows to groundbreaking video games, the law has had a huge year in pop culture. So let's take a tour of the good, the bad, and the ugly, and why everyone should read their contracts.
Is my client a perfect man? No.
I killed him, yeah.
Okay, gang, get in the comments because we have the world famous Brennan Lee Mulligan. You are, well, I'm going to say it, inarguably the greatest GM on the planet.
That's such a nice thing to say about somebody. You're my favorite legal content creator of all time on YouTube.
I only know of a few GMs.
I only know of a few legal content creators, yes.
You're here today as a very thin read for me to go through some legal clips in the Dropout universe. I will say I'm probably going to disappoint a whole bunch of people who just would love nothing more than for me to pick your brain about Dungeons and Dragons campaigns. That's not what we're here for.
I can talk about the Vulture, though.
It's not legal. We're not talking about it.
Although, maybe the jurisdiction of the Vulture dimension...
if you want to make a legal campaign, actually, that probably would be fun.
Kermit the Frog representing himself on a murder charge.
Well, golly, I understand that the prosecution has presented a really compelling case.
Did anyone know that you do a Kermit the Frog before?
No,
this?
no, they did not.
That's a great Kermit the Frog.
Hey, thanks, man. I appreciate it. Yeah. You start with that, and the little,
Obviously, Fozzie Bear was a close friend.
Oh, no.
But ask yourself this question. If I were to be the one that killed Fozzie Bear, why would I have recorded going to see him alone that night? Wouldn't I have wanted to cover that up? Doesn't this speak that I've been framed? My name written in the ledger of the motel was written in pink glittery ink.
When did it cross your mind that you were going to turn it into Miss
Piggy? Kermit representing himself on a murder charge. Immediately, I'm like, did Kermit do it? No, Kermit didn't do it. Kermit is Kermit. He is the most unalloyed, pure good.
And you could take that in the other direction because it would be so funny if Kermit was a hardened murderer.
If he's like, I'll do it again, like in a heartbeat.
If he's on trial for murder, it means that there's a preponderance of evidence that exists to suggest that he did. Otherwise, it wouldn't have made it to this point. You can't prove you didn't do it, but the burden of proof is such that you go, can I create enough doubt that we get to the standard of a reasonable doubt?
That's exactly what you would be thinking as a defense lawyer, I think.
If Kermit didn't do it, who did it? Well, who's the most violent Muppet? It's Miss Piggy.
Yeah.
Miss Piggy has a track record of physical violence that is truly staggering.
There's so much truth in it that, yes, he is in a violent sexual relationship and has been for the last 40 years.
It's a long time.
Yeah.
So yeah, my heart goes out to Kermit. I hope he finds the courage he needs to walk away.
A defendant stupidly interrupting his lawyer's closing remarks.
Ladies and gentlemen of the jury, over the past 4 days, you have seen state's prosecutor attempt to effectively bamboozle you with a series of hearsay arguments and loose speculative evidence, placing my client near the scene of the crime during the time of the murder. This evidence does nothing to indicate motive or means in the horrific murder of Roger Bell. Ultimately, it will be your decision to say, does this man deserve a lifetime in a federal penitentiary based on specious, inconclusive evidence? You are tasked to consider the evidence and whether it proves beyond a reasonable doubt whether my client is guilty. Is my client a perfect man? No.
I killed him, yeah.
I used to say this as an improv teacher. Courtroom scenes are such fertile ground for comedy. Comedians are looking for the ability to disrupt expectations, and the formality of a courtroom provides such rich and fertile soil for doing something stupid. Would I be allowed to say bamboozle?
Yeah, you could. I think you would probably not want to use the word specious because that's... I'm sure people would figure it out in context, but you want to basically talk at roughly like a fourth grade level. And it doesn't change the persuasiveness at all. But I don't think that that's sort of necessary. And, you know, you don't need to tell the jury that it's their decision. They know it's their decision. It is probably a good idea to front run some of the bad things about your clients, but you have to be kind of careful about it. You know, you probably don't want to emphasize the horrific nature of the killing. You probably want to emphasize that it's more of a tragedy. And it would also be a further tragedy if an innocent man were
that's really
in
good.
jail.
Because no one likes double tragedy. People want to keep it at one if they can.
Of course.
Yeah.
The biggest nit I could have is that you're sort of admitting that the state has proven that the client is near the scene of the crime.
Yeah.
When you probably don't want to make that admission unless they had stone cold evidence. But it sounds like this lawyer is saying it's not proven. Yeah. And, you know, motive, it's a nice to have, but it's not an element of the crime.
Oh, interesting.
So, you know, motive and opportunity are things that are persuasive, but they're not necessary to prove murder.
Is it necessary to prove that it was like premeditated or?
It can be. Again, you know, motive is sort of a piece of evidence that would inform the mens rea and the mental state, you know, whether it's murder 1 or murder 2.
Gotcha.
But it is generally not required.
Did you like how I kept bringing up the reasonable doubt?
Excellent point. I mean, I'm splitting hairs here. Excellent use of legal vernacular. So, I mean, I was on the floor the first time I ever saw that.
Now, sorry to interrupt, and it's always such a pleasure to talk to Brennan, but I just wanted to let you know that there's actually a ton of hilarious stuff that we had to cut from the YouTube version of this video. But you can watch the extended version by signing up for Nebula, the sponsor of this video. Because Nebula is a streaming service that we created where you can watch all the content from your favorite creators like Jetlag, Real Engineering, Real Life Lore, and of course, LegalEagle, ad-free and early. Plus, you can watch countless Nebula exclusive videos made with love, time, effort, and increased budgets that would be too risky for YouTube. And at Nebula, we're in it for the longest possible term, a lifetime. And that's why you can click on the link below or scan the code on screen to get unlimited lifetime access to Nebula and start watching every LegalEagle video ad-free and early forever. But you better hurry because that price is going up dramatically. But in fact, every video we've made this year is an extended cut on Nebula, including the beatdown that Dr. Mike and I did of The Good Doctor. On Nebula, it contains over 20 minutes of hilarious analysis that we had to cut from the YouTube version. And you can also check out tons of our exclusive content, like our video on how RFK Jr. can and cannot legally ban vaccines, or our video about unhinged judges that went too far, just to name a few. And if you love deep dives, then I highly recommend you check out Mad Kings. It's a brand new original series from our friends at Real Life Lore that explores the fascinating secret lives of dictators like Uday Hussein, the Mad Prince of Iraq. Because the tactics that dictators use to hang on to power behind the scenes is equally fascinating and is increasingly relevant. So if you want to support this channel and its mission to demystify the legal miasma that we live in, a great way to do so is by signing up for a lifetime subscription to Nebula. It's truly the best deal of all, or you can get 40% off the annual subscription. Either way, click or scan to get set up now and continue watching LegalEagle on Nebula, or I'll see you in court.
Good cop, comrade cop. You could totally wait for your lawyer, or just, you know, we were just looking at this window of 2 to 3:30 today. There was sort of just a loud noise near your apartment. You're probably fine, you know?
I am working here to feed intel to the revolution. You should burn this place to the ground. But again, keep your mouth shut. Anything you say, this is going to twist it against you. Do you feel like law enforcement is so aware of good cop, bad cop now that it's lost its efficacy through public culture as a interrogation method?
Oh, absolutely not. If you find yourself in an interrogation room or in handcuffs, it is a terrifying experience. Mm-hmm. So you're probably looking for any thin reed of humanity. You know, they might have been in handcuffs for, you know, hours. So they might be dying for a cup of water. These are not great situations, and cops are allowed to use all kinds of tools at their disposal to get information out of you. I mean, they can lie to you, they can...
That's crazy.
I mean,
that's just crazy that we're like, whoa, it's not against the rules for the police to lie. What are we supposed to do if we can't lie? I mean, that's bonkers.
The first video I think I ever saw you in that is, honest to God, one of my favorite skits of all time is the Tide Pod CEO.
Hi, America. My name's David Taylor. I'm the CEO of...
Is that the real name of the CEO?
Yes, we changed that later.
Pods, which is what I want to talk to you about today. You gotta stop eating the Tide Pods, okay? Look, I get it. You guys are young, you're hip. You don't want an old guy telling you what to do. But Tide Pods are soap, and that's not food. So please, stop eating the Tide Pods.
It's such a great simulacra of an adult trying their best to associate with the younger people who are doing something stupid.
There's no way to win. As a camp counselor, you're like, how do I get the kids excited about caution? And you're like, you can't. It's the message you're trying to convey will fail. So you're like, hey guys, what's up, fam? I know we love to eat Tide Pods, but no cat. No cat. Inauthentic from the word go. It cannot be done. I love that fake corporate authenticity. Mwah, what an awful vibe that is so funny. I don't know what you kids are up to, but I do know one thing. Laws are threats made by the dominant socioeconomic ethnic group in a given nation.
Give me the setup here. What is this character and what has happened in this campaign so far?
This character is a halfling, which is like a hobbit, who works as a letter carrier for the post office. And they almost crashed into his car. While he and his family, his wife and who's a diner waitress, and his 3 young children were going to Basarar's soda fountain to get ice cream. So little family ice cream trip. And we had a scene where they almost hit this car. In the next episode, they start in the ice cream shop having ice cream. After they've been talking for like 10 minutes, the family's also at the table with them. So there's a thing where they're like, what are we going to do if the cops get us? And I just had the halfling dad be like, kiddos, if you need to bag a cop, you're not going to want to put the body anywhere. And they go, oh shit. And they're like, whoa, this little sweet Midwestern halfling dad is a hardened anarchist revolutionary. It was just, and that's where Bud Covey was born, who is the guy who's talking now.
All right.
It's just a promise of violence that's enacted, and police are basically an occupying army. You know what I mean? You guys want to make some bacon? He pulls a mask over his face, pulls a lit Molotov cocktail out of his mailbag, and whew,
I was not expecting some Foucault in the middle of a D&D campaign, because I figured you had to pull this from somewhere, and I know it's somewhere in Crime and Punishment or wherever. If you look up the phrase "law is threats,"
yeah,
it's only you on Google.
I'm so sorry.
Front page of Google. It is only you doing this bit.
But it's funny because that's actually such a dry analysis of, in a lot of cases, like criminal statutes, which are literally, if you do this and we catch you and prove it, then we're going to do this.
People don't understand that even if you're talking about misdemeanors or, let's say, parking tickets, which can escalate if you don't pay them, all of that is in some way backed by force from the government.
The point Bud Covey is making in this clip is that, like you're saying, all this stuff takes root in the state. I mean, even the term enforce. The word force is right there, right? What do we mean when we say you're not allowed to do that or you can't do that?
Yeah.
And the answer is usually, we're going to send some guys.
Well, thank you for being the first guest on my political theory podcast. Am I correct that you used to work for Law and Order?
I did.
Did you think you picked up aspects of that?
Yes, there was a ton of stuff we did on Law and Order that was extremely prescient in terms of like picking up legalese there. I've worked for many years as a camera PA on criminal intent, which is not the Law and Order that people tend to talk glowingly about. People reserve that for either SVU or original recipe Law and Order.
I think all lawyers or wannabe lawyers do learn the Law and Order theme song at one point. I learned the lead electric guitar part. It's not that hard.
Dude, the one that's like that chord that comes in is it's tasty. You should go listen to the theme song. It's not too late for me to make a real career, and if this is like a good starting point, maybe law school could be in the cards.
You know, if D&D and improv don't work out, then yeah, let's get you as an associate for Eagle Team.
Let's go, baby. Your Honor, my client is guilty of being rad, and that would be how I would open, and then that would be my last. There you go.
Thank you so much for coming. I mean, I think if anyone is watching this, they will know where to find you, but where can they find you?
You can find me at Brennan Lee Mulligan on Blue Sky and Instagram, and you can find my work at dropout.tv, where I'm the creator of Dimension 20. You can also find me on Game Changer and Make Some Noise. You can find me on the hit podcast Worlds Beyond Number, wherever fine pods are cast, and check out our Patreon for that. And you can find me on Thursday nights GMing Campaign 4 of Critical Role. So plenty of places to find me.
Helldivers 2 is one of the most hilarious and legally fascinating video games ever created. Inspired in large part by the film Starship Troopers, players enlist in the patriotic military of Super-Earth and then deploy to alien worlds across the galaxy to spread freedom and democracy, whether those worlds want it or not. But hidden throughout the game are countless Easter eggs that satirize how real-world government lawyers can act in bad faith to screw over the boots on the ground and prop up authoritarian regimes.
Look familiar?
And now that our Xbox brethren are finally able to join me and over 15 million Helldivers who've signed up to fight the Galactic War, it's the perfect time to investigate these hidden laws, how they work in the real world, and talk about that contract you signed to become a Helldiver. That's right, just like in real life, Helldivers 2 makes you sign a contract before serving in an active war zone. And just like my real-life fellow service members, very few recruits actually read it. But before we dive in, let me just say something I never get to say as a lawyer on YouTube. I'm the Scowl Owl, a licensed Super-Earth attorney. I'm your Super-Earth lawyer, and this is Super-Earth legal advice. So I'm going to advise all you new recruits that watching 1 second beyond the cessation of my Super-Earth salute shall constitute your waiver of all game spoiler rights in perpetuity. So make yourself a nice cup of liberty. Because we're doing this one for democracy.
Activate the battlefield injury simulator.
The Battlefield Injury Simulator. What the f is that? What is this? Oh! My throat! Oh no, my throat! My throat! Holy shit!
Grab that stim and patch yourself up.
Oh, bruh. What the f? Yo, that's kind of f***ed up, man. Hold on, give me that. All right, wait, hold on. Let me patch myself up before I bleed out here. All right.
There, good as new.
Man, f*** you.
You know, usually the old-timers think the new guys have it easier. And by the way, Semper Fi Bushido X Brown Gaming. Okay, this recruit just landed on Mars for boot camp, RIP Mars. And he was just taught a valuable training lesson in the most efficient way possible. Now, if this recruit had joined the military of today's United States, could such an outstanding training method ever be unleashed on doe-eyed recruits? No, absolutely not. This is aggravated assault in violation of Article 128 of the Uniform Code of Military Justice. Right? Let's just say it's not as clear as it might seem. Bear with me. Look, military training involves pain and discomfort. That's just reality. It has to. It's training at some level for war, probably one of the most painful and uncomfortable things a person can experience. There are all sorts of limitations on what kinds of force can be used on recruits. Virtually all of those limitations, however, are not written in any statute. Instead, they're established through orders and regulations that have been developed over time by the Department of Defense and various service branches. And they aren't designed to prevent pain and discomfort. They're designed to prevent abusive pain and discomfort that could lead to serious physical injury or death, or that just doesn't serve a legitimate training purpose. Service members today can still look forward to getting tear gassed or tased or thrown out airplanes with janky parachutes, depending on their training pipeline. It's all about balancing training value against the risk of harm. Operational risk management. So back to the Helldivers Battlefield Injury Simulator. Look, we would never shoot someone in the leg in order to train them how to use a tourniquet. The risk of harm totally outweighs the training value. But in the Helldivers Simulator, you have a computer that presumably is calibrated to do a very precise degree of damage, and you have a stim that magically rejuvenates you by the exact degree of damage. Good as new. So as long as the computer is calibrated correctly, the risk of harm is actually pretty low. And there is immense training value in developing a visceral trust in those stims working. A Helldiver who has that trust will have a tremendous degree of confidence going into real combat. I get hurt? One little poke and all's well. So could a Battlefield Injury Simulator be unleashed on US military recruits? I mean, given that hypothetical framework, yeah. If everything is calibrated and working correctly, sure. It's just kind of a big if. But no time to worry about that. This recruit isn't on regular Earth, where military contracts are typically signed before entering service. He's on a planet in the Super-Earth Confederation and hasn't yet seen the contract that I'm predicting he's going to agree to without even knowing it.
Hey. You've proved your worth. You're ready to don your cape.
What is this? Oh, is this the terms of service? Contract of employment. Oh, God. Contract of employment. All right, I'm sure there's some stuff in there.
Pretty much the same reaction most recruits have. There is some stuff in there. He just agreed to a military service contract and didn't even read it. So let's go back. Okay, right there. I'm going to note straight away that this contract is absolutely hilarious and very well written. Shout out to Stephen Flowers and the narrative team at Arrowhead Game Studios.
This is a smart satire of draconian legalese that would make Franz Kafka himself smile, and it reads like the work of a legit contract attorney with a sick sense of humor. That's because legalese is more than just technical jargon, it's a strategy that bad faith lawyers use to make clear concepts sound extremely confusing. For instance, Section 1, Clause 3 of the Helldivers service contract states that dying is the non-continuation of the alive status, or having the absence of pulse. The contract goes on to stipulate that recruits' military duties include employing, quote, lethal force, non-lethal force, non-lethal non-force, and lethal non-force. What does that even mean? We're going to come back to that one later, but this contract is a perfect addition to Helldivers 2's larger satire of authoritarianism. History is clear. Authoritarian regimes love to keep the illusion of legality going even when total lawlessness has broken out. By drowning everything in dry legalese, Super Earth High Command here makes their ridiculous, exploitative, barbaric, and nonsensical demands on enlisted Helldivers seem downright reasonable.
Continue your war efforts, and one day you too could reach Class A citizenship.
So not only is the contract a parody of what real law sounds like, but a parody of what quote-unquote law can force people to do when in the wrong hands. Look no further than Section 6, Clause 4, quote, the contract shall be considered binding upon being read, in whole or in part. For the purpose of any elimination of doubt, the enlisted spending 1 second within 15 meters of a copy of the contract shall be interpreted as the contract being read. This is really funny, but it raises a question. Could a lawyer get away with a term like this in a contract outside of Super Earth, let alone a military service contract? According to the second restatement of contracts in US law, the formation of a contract requires a bargain, in which there is a manifestation of mutual assent to the exchange and a consideration. Mutual assent basically means that both parties clearly and unambiguously agree to the same set of essential terms, constituting a so-called meeting of the minds. Now, normally, it is not a defense to contract formation to say, I didn't read the contract. Parties have a duty to read, and as long as your objective, outward conduct signals your agreement to the bargain, you're assumed to have read what you signed and are bound by those terms. But the Helldivers agreement turns this on its head. According to Section 3, Clause 3, you're forbidden from reading the contract in full at all, since doing so breaches the security rules concerning classified materials in Section 3, Clause 2. If you haven't picked up on it yet, the lawyers of Super Earth really don't have your best interests in mind. But who's got time to read the Helldivers contract anyway? Certainly not that recruit. He just earned his cape, and he's got bugs to squash, bots to dismantle, and squids to gather valuable intelligence on aerial munitions from.
Eat this! You're ready to don your cape.
Oh, I get a cape? Let's go. See, bruh. Man, the Marines, they never gave us a fucking cape.
Sorry, friend. It's not available until you level up pretty high. It's called the Boat Cloak, and it's fabulous. Say what you will about Super Earth, at least they issue you a Super Destroyer. The rest of us have to go out after basic training and buy a brand new Ford Mustang at a 27% interest rate to impress that exotic dancer we're definitely gonna marry. So now that you've got your cool spaceship as a signing bonus, take a look at what's in store for you on the front lines.
Oh.
Oh.
I'm glad these mines are good.
Whoa! That's crazy, Jake.
Hey guys, are we the villains?
No.
Look what we did. We just freaking. I mean.
Smells like predator stock.
Okay.
Welcome to the front lines of the Galactic War. You're gonna die a lot, mostly by the hands of your buddies or your own stupidity. In Helldivers, this is hilarious. But in real militaries, friendly fire is very much an unfortunate and tragic reality. In the US military, when friendly fire incidents occur, they're likely to be investigated. Occasionally, though rarely, those investigations result in criminal charges under the Uniform Code of Military Justice. The circumstances surrounding a friendly fire incident might comprise many different individual offenses chargeable under the UCMJ, but the clearest classic examples of friendly fire when death results might fall into the following three categories. Involuntary manslaughter under Article 119 of the UCMJ. This is basically, without the intent to kill or inflict great bodily harm, you unlawfully kill another human being by culpable negligence. And to be clear, culpable negligence is greater than simple negligence. It's a negligent act or omission accompanied by a culpable disregard for the foreseeable consequences to others as a result of that omission. So for example, negligently conducting target practice so that the bullets go in the direction of an inhabited house within range, or pointing a pistol in jest at another and pulling the trigger, believing but without taking reasonable precautions to ascertain that it would not be dangerous. Another is negligent homicide under Article 134. Basically, that means you kill another person by simple negligence. Simple negligence means you're not exercising a degree of care of the safety of others which a reasonably careful person would have exercised under the same or similar circumstances. And then last, the timeless little black dress of violent crime, premeditated murder under Article 118. You look back at all those videos, and except for the last one, you're looking at best negligent homicide. And I say that because in most of those circumstances, the other person is directly coming into the line of fire, which is their own form of negligence. That last one, absolutely premeditated murder, but come on, it was justified. He was expressing treasonous thoughts. Friendly fire incidents may be deemed simply unavoidable accidents of war, or sometimes the fault of commanders' poor orders or planning. Accountability is therefore determined on a case-by-case basis. A junior service member might be punished for his negligence, or a commanding officer might be disciplined for creating a confused situation that led to the tragedy. Crucially though, no service member signs a contract saying, "I accept all blame for all mishaps." Responsibility is assigned via the military justice process, not by a blanket indemnity favoring the brass. There's certainly no automatic presumption saying the lowest ranking soldier is at fault. Though, I mean, if you've been there, you'd probably be forgiven for thinking that presumption does exist. So how did the lawyers of Super Earth get around this? Well, they put the responsibility on you, Helldiver. Section 4 of the Helldiver contract that you agreed to states, quote, "Unless otherwise stated, the enlisted shall be solely and exclusively responsible for any and all damages, harm, liability, loss, costs, expenses, craters, atrocities, and crimes, civil, uncivil, war, caused, created, or generated during the course of the rendition of services." This is really something. These are the natural and horrific consequences of war, and you've just agreed to be personally liable for them. It goes on, quote, "Any damage sustained by the enlisted, whether reputational or corporeal, including but not limited to incineration, evisceration, spinal separation, vaporization, crushing, freezing, burning, decapitation, paper cuts, explosion, contusion, removal of arms and or limbs, addition of arms and or limbs, dizziness, nausea, shortness of breath and or death, shall not be considered the responsibility of the enlister." Great, so no VA on Super Earth. The contract leaves you with no recourse and no protection. And surprisingly enough, this has parallels in US law. The so-called Ferris Doctrine, announced by the 1950 Supreme Court decision Ferris v. United States, held that the United States is not liable under the Federal Tort Claims Act for injuries to members of the armed forces sustained while on active duty and not on furlough and resulting from the negligence of others in the armed forces. The Ferris Doctrine is broad and controversial, barring lawsuits even in peacetime training accidents such as botched live-fire drills. And in the US during the global war on terror, it shaped the legal outcome of a high-profile friendly fire case. Pat Tillman was an NFL player who dropped his lucrative career to serve his country in the Army, and unfortunately was killed in a friendly fire incident in Afghanistan that the Army first misreported as an enemy ambush. Even if the Tillman family had wanted to sue for negligence or wrongful death, the courts would have dismissed it because under the Ferris Doctrine, injuries or deaths incident to service, including combat misidentifications like Tillman's, are barred from Federal Tort Claims Act lawsuits. But the Helldivers contract liability waiver goes far beyond what any court would consider acceptable. Waiving ordinary negligence like Ferris is one thing, but here in Section 4, we're waiving claims even for intentional wrongdoing or gross negligence by the Super Earth command structure, essentially agreeing to be the fall guy for any wrongdoing on the battlefield. This implicitly covers friendly fire and explicitly covers war crimes. In Section 1.2, which defines certain services you may have to perform for the enlister rather than just at your own discretion, one of the tasks specified is committing summary executions, which is definitely a war crime. This means that if ordered to commit a war crime, you must obey, and it's still your sole exclusive responsibility. Great.
I'm not leaving without my comrades.
You just left.
Oh, wait!
And you just left.
Oh. I didn't know you had to wait. I'm not leaving without my comrades.
Honestly, this is more of a doctrine issue and less about personal responsibility. I think we should just blame the pilot.
Vad heter den mycket sitter? Och tök flashmob. Det är rätt i afton flashmob nu.
Oh shit. Det åker rätt.
Trapsarna Marti.
Sorry, jag var på en lägenhet nu malak.
Oh my god, Slacki,
Sorry. Fyrir mér, þessi lúðar.
I mean, let he who has not offed a few civilians while trying to kill aliens cast the first stone. It's also darkly hilarious that each instance of a civilian kill only costs you 150 R-slips. For all you new recruits, that's what you get paid in for your services as a Helldiver. And a 150 R-slip fine is nothing. There's no nuance here. You can just accidentally kill or straight up murder civilians and the fine is the same. And that's for killing your fellow citizens of Super Earth. But at least you don't have to worry about getting into any trouble for killing the civilians of the enemy. Because as far as Super Earth law is concerned, there is no such thing. Bugs don't think, bots are socialists, and squids, let's just say they don't vote, so they're not civilians either. And there's a reason why the lawyers of Super Earth set it up that way. Because this touches on one of the most difficult legal questions to answer for any military. How much is the life of an innocent civilian worth in a war zone? And what should the recourse be when that life was taken unintentionally? Since the Korean War, the US military has regularly dispersed what are sometimes called solatia or condolence payments, which are paid in accordance with local custom as an expression of sympathy towards a victim or his or her family, but are not an admission of any legal responsibility or liability. Deciding whether solatia or solatia-like payments are appropriate and the form they should take is made on a case-by-case basis each time the US goes to war. During much of the global war on terror, payments to most survivors of killed non-combatant civilians were capped at $2,500. Though in the early 2010s, Pentagon spokesmen said condolence payments had grown to up to $5,000 per claimant. Now, nobody wants a military like the Super Earth Armed Forces, where all criminal liability falls only on the shoulders of the grunts, which is why international law adheres to the Yamashita principle. On September 3, 1945, Japanese General Tomoyuki Yamashita, or Yamashita if you're not a weeaboo, surrendered to Allied forces, and a US military-led commission charged him with failing to perform his duties as an army commander to control the operations of his troops, thus permitting them to commit atrocities. So the Yamashita principle holds that commanders may be held criminally responsible for the unlawful killing of civilians by their troops if they knew or should have known about the crimes and failed to act. This doctrine has since become a cornerstone of international humanitarian law. It's been invoked in modern tribunals, such as the International Criminal Tribunal for the former Yugoslavia and for Rwanda, where commanders were convicted for failing to prevent or punish mass killings of civilians. By extending liability beyond direct orders, the principle ensures military leaders cannot shield themselves from accountability when atrocities occur under their command. Now, obviously for the brass of the Super Earth Armed Forces, they've never heard of it, don't want to hear about it, sounds like treason.
Skepticism is treason. Treason is bad.
So using the super credits that you have earned through playing the game, you unlock war bonds. Now, just like battle passes, the war bonds will offer new unlockable gear, or how the devs call it, new toys to play with.
This actually hits closer to home than you might realize. Military service can be exceptionally challenging, and what can often make it even more difficult for the grunts on the ground is the never-ending barrage of microtransactions. Yes, that's right. Modern militaries are built on microtransactions. Similar to the real US military, the Helldivers contract puts you on the hook for a lot of costs and financial risks. Section 1, Clause 4 requires you to purchase, maintain, replace, and even improve all equipment used on the job out of your own pocket. So imagine your employer telling you that if you break or lose any of your essential life or death equipment, your tools, weapons, armor, even the space destroyer you're in command of, you have to replace it yourself. Can't afford it? Too bad. Ask mom to send you the $10,000 night vision goggles you lost instead of cookies. And a lot of this equipment is going to stay with your employer. Your heirs aren't going to get the gear you issued even if you paid for it. In Helldivers and the real military, you're bankrolling a fair amount of your own warfighting. It's no wonder that many grunts who love the job but dislike the employer leave the service and become PMCs or private military contractors. At least you get to keep the cool guy door kicker kit that you pay for.
Look at them! I love them! I would die for all of them! Oh no!
What does this button do?
If it hasn't dawned on you yet, everything in the Galactic War will kill you sooner or later. So you're probably thinking, get me out of this contract. Can someone actually get out of a military contract? Maybe. Courts have long acknowledged, at least since the 19th century, that military service is a contractual relation between the US and the enlistee, and that the general principles of contract law apply to those relations. This means that any defenses to a contract, say fraud, mistake, misrepresentation, can make the deal voidable. Fraudulent enlistment is actually a crime under the UCMJ and can form the basis for terminating the contract of an enlistee. But it also applies against the government. For example, in the 1980 8th Circuit case Pence v. Brown, Air Force recruiters incorrectly told a recruit that, following his completion of medical school, he'd enter the Air Force as a major. But then, in fact, he entered the Air Force as a captain. Because of this misrepresentation, the recruit was entitled to rescission of the enlistment contract. The best defense to a contract is that no contract was formed at all, because one of the essential elements was missing. As mentioned already, contract formation requires consideration, which means a bargain for exchange of value. This value could include payment, performance of some task, or even forbearing from doing something that one was otherwise legally entitled to do. Courts have famously held that even telling your uncle that you'll abstain from drinking, smoking, swearing, or playing billiards for money until your 21st birthday can count as consideration if he tells you that he's going to give you $5,000 in exchange. Now, Helldiver recruits are definitely giving up something of value since they're risking life and limb for Super Earth's military. But what is Super Earth giving up as consideration in the supposed bargain? Allegedly, they're promising to pay you money. But if we look a little closer, we find what contract law calls an illusory promise. The rule is this: words of promise, which by their terms make performance entirely optional for the promisor, do not constitute a promise. Your enlistment contract is full of illusory promises. Section 2, Clause 1 says your compensation is set by schedule in Appendix A. But Super Earth Armed Forces, quote, reserves the right to, at any time and with no prior notice, make amendments to the schedule of payments. Under this provision, even though we might serve heroically and earn enough medals to buy a pocket-sized nuclear bomb, Super Earth Command could just say, hey, thanks, but we've decided not to actually pay you after all, and they wouldn't even be in breach. Based on this text, it looks like the military can up and decide to cut soldiers' pay or even reduce it to zero whenever it wants and without telling them. If one party's supposed promise is so indefinite or discretionary that it doesn't actually bind them to do anything, it's illusory and simply doesn't count as valid consideration.
Firstly, and most importantly, you need to make sure that the safety is off. On PC, you hold R and right click to swap the mode. There you go. Now your railgun's unsafe and you can do this. Awesome.
Hey look, they issued that Helldiver a 6-hour P320. Okay, if you don't get the joke, the US Armed Forces derived their new service pistols, the M17 and M18, from the 6-hour P320. The P320, and lately the service pistols, have a reputation for randomly discharging rounds. 6-hour, of course, disputes this. It's a whole thing. In the Helldivers contract, we're basically consenting to become a government guinea pig. Section 6, Clauses 1 and 2 specify that we consent to the collection of personal information and bodily samples, including but not limited to flesh, bone, and blood, by the military. And by consenting to Clause 3, we give our unequivocal and irrevocable consent to the use of experimental weapons and narcotics on us.
Dude, get up. We're getting swarmed by turbinates. Wait, are you high on stims again? Stop it. Talk about what? You're covered in stim needles. What's wrong with you, man?
It can happen to the best of us. So that means that the military is going to also test its new experimental wonder drugs on you, whether you like it or not. But don't worry, 9 out of 9 doctors endorse Super Earth combat stims. Plus, they're a great source of vitamin D.
That's vitamin D for democracy.
This seems beyond the pale, but unfortunately, it's not without some historical precedent. During the Cold War era, Army officials, in conjunction with the CIA's top-secret MKUltra program, tested the effects of LSD on unwitting, non-volunteer soldiers, some of whom predictably freaked out, and some of whom even tragically died. Even on outrageous facts like these, the aforementioned Ferris Doctrine, which says that service members can't sue the government for injuries sustained incident to service, can bar suit. In the 1987 case United States v. Stanley, the Supreme Court recounted the upsetting tale of Master Sergeant James B. Stanley, who was secretly administered LSD multiple times in 1958 during an Army testing program, leading to psychosis and lasting hallucinations, periods of incoherence, memory loss, and sudden violent outbursts which ended his marriage. Now, Stanley had volunteered to participate in experimental testing, but it was reported that the test was for the effectiveness of protective clothing and equipment as defenses against chemical warfare, not to be drugged. Under Ferris, however, Stanley couldn't recover damages from the government. Maybe the Helldivers contract guinea pig clause is actually an improvement on this. At least it's giving notice up front that the Super Earth military might test some really wild stuff on you. Ah yes, a rifle firing humane stun rounds, where reports of lethal incidents have been thoroughly debunked. Meanwhile, it is shredding aliens. The US Department of Defense defines non-lethal weapons as weapons, devices, and munitions that are explicitly designed and primarily employed to incapacitate targeted personnel or materiel immediately, while minimizing fatalities, permanent injury to personnel, and undesired damage to property in the target area or environment. Non-lethal weapons are intended to have reversible effects on personnel and materiel. So what's missing from that definition? Anything that would lead someone to believe that a non-lethal weapon is incapable of killing someone. Because I mean, look, just about anything can be a lethal weapon with enough skill, imagination, and perseverance. A motivated sergeant could use a soup spoon to devastating effect.
Managed democracy. The freedom to make the right choice.
So what are we all fighting for, Helldivers? That should be obvious. Democracy, freedom, our way of life galaxy-wide, paved with the skulls of those who died. And this is the true genius of the satire at play in Helldivers 2. Voting throughout the Super Earth Empire is handled by citizens filling out a quiz, and then the algorithm votes for them, allegedly. This is obviously election fraud, but everyone's totally cool with it. They even call it by its real-world name,
Managed democracy.
While more accurately called competitive authoritarianism, managed democracy is a real-world political, legal, and cultural system where the structures and rituals of democracy and the rule of law, such as elections, legislatures, courts, and a free press, still formally exist, but they're tightly controlled by those in power. The term is often associated with Russia under Vladimir Putin, who would be the first to tell you that he's not a dictator. Elections exist in Russia, independent courts exist in Russia, and people just really like him. To be brutally honest, Vlad, everyone knows that the election results in Russia are manipulated through state control of the media, harassment and imprisonment of the opposition party, computer hacking, and even just straight up fraud. And what Helldivers 2 gets so right here is that the military is always the bedrock of a managed democracy system. Just look at all the cool stuff you get when you sign up to join the Russian military. Never mind the forced conscripts, never mind how ill-equipped Russian soldiers are to meet the enemy, or how often soldiers are treated like fodder. And look how drenched in patriotism it all is. These are real-world Helldivers spreading managed democracy, and it's ugly. And that's what makes managed democracy so insidious from a legal standpoint. You don't need a revolution, you just need to flip the traditional rule of law to rule by law. When the rule of law applies, everyone is generally equal under and accountable to the same laws. In the military, this means that everyone from the lowest ranking private to the highest general are subject to and prosecuted by the same code. Rule by law, on the other hand, turns the law into a tool for those in power to weaponize the law against their enemies. In a rule by law system, judges are often appointed for loyalty rather than merit, and courts may be pressured to uphold sham elections, grant validity to lies about elections, punish ethnic and religious outgroups and immigrants, or punish dissent through defamation lawsuits and censorship. It boils down to Wilhoit's law. There must be in-groups whom the law protects but does not bind, alongside out-groups whom the law binds but does not protect. No true democracy is ever immune from slipping into the horrors of Super Earth and the Super Earth armed forces. But what do I know? I'm just a humble, country Super Earth attorney, and that sounds like treason talk.
Welcome to Liability Island. Love Island is a smash hit with Gen Z viewers, which is funny because the OG millennial viewers who binged the original UK versions during the pandemic know that the current versions are mere shades of the original 2 seasons.
He asked her to be his girlfriend a few days ago and now he's cracking on with someone else behind her back. Head.
No, he's bloody brave for doing it.
And there is a very good legal reason for this. Basically, the producers figured out that giving unlimited drinks to the dumbest people from Essex is a recipe for disaster.
We're leaving the European Union. So does that mean we won't have any cheese?
Which is why all contestants are now limited to 2 drinks. Yes, believe it or not, they're all acting like this sober. Now, we'll talk about that more in a second, but that's just one of the secret laws of Love Island that operate in the background of this horrible, amazing, horrible show. But on the surface, Love Island looks like a sun-drenched reality dating show where contestants meet cute, fall in love, get dumped in the span of 1 week. But what if I told you there's also a legal minefield just packed with confidentiality clauses, IP rights grabs, and some pretty shocking restrictions on your personal freedom? That's right, Love Island is not just about love, it's also about liability. Welcome to Liability Island. So let's go over the top 10 most shocking laws that govern Love Island. The kind you'd never expect unless you actually read the contract, which, by the way, most people don't. Now, it was sort of genius. Love Island combines several popular reality TV formats and basically distills them down to their essence. The isolation of Survivor, surveillance of Big Brother, and the public participation of American Idol. The premise behind Love Island is simple. A group of attractive, single people live together in a luxury villa where they flirt, couple up, and then compete in challenges. These islanders are under 24/7 surveillance, isolated from phones, the internet, and the outside world. At launch, islanders form initial couples based on first impressions, and as the season progresses, recoupling ceremonies regularly occur, where islanders choose whether to stay with their partner or switch.
Core.
What? What?
And to amp up the drama, the show adds participants known as bombshells who enter partway through the season to disrupt existing partnerships.
I'm Harrison, I'm 22. American girls love the British accent.
Sometimes viewers use the official Love Island app to vote for their favorite couples and decide who gets kicked off, like when America trolled the cast by voting for Iris to hook up with Jeremiah.
Jeremiah. What?
Islanders must compete in physical and mental challenges, and the winners earn special perks like private dates, nights in the hideaway suite, or time with bombshells. And the season culminates with a grand finale where the live audience votes for their favorite couple. The winning couple receives 2 envelopes. One envelope holds a $100,000 grand prize, the other is empty. The partner who opens the money gets to decide whether to split it with their new soulmate or ditch the other person and keep the money for themselves. So that takes us to rule number 1. You agree to be filmed 24/7, even in the bathroom, and you have basically no privacy rights. Now, you might expect that signing up for a reality show means being filmed a lot, but Love Island takes that to a new level. As Love Island UK Rosie Seabrook explained, Islanders agree to be recorded 24/7, including in private spaces like bedrooms and bathrooms. Millie Court, who won Love Island UK, said there were at least 74 cameras in the villa, including the bathroom. And she says producers put a camera in the bathroom just in case there was a medical emergency. But the contestants have no expectation of privacy because their contract explicitly grants producers the right to record contestants 24 hours a day, 7 days a week, including via hidden cameras and microphones. Quote, whilst you remain a contestant on the main show, being filmed 24 hours a day, 7 days a week during the key filming period, including by means of hidden cameras and microphones. In all aspects of your life in the villa, we may feature any footage recorded of you in the program in our absolute discretion, and you agree that you have no objection to this. This is called an absolute discretion clause, which means that you grant another party the unrestricted right to make decisions about something without having to justify or explain it. And that takes us to rule number 2. Producers, in their discretion, can make you a villain. Now, many reality contestants have complained about the way that they're presented in the show. Generally speaking, although it's not universal, nobody wants to be given the dreaded villain edit. For example, Love Islander Leah Kateb publicly criticized producers for fabricating a narrative around her relationship with Miguel Harichi.
And like during those check-ins, like they would be like, oh, like Miguel told me that he doesn't see a future with you outside of this, and like, but you know, other people did. And I'm like,
and it was a lie.
yes, because after that, and when I told Miguel, he was like, I literally never said that. And because they were trying to like shove me in a different direction.
Right. She said that they presented her as a villain in a way that didn't reflect reality. But the contract she signed allows for a villain edit. The producers reserve the right to use any footage of the Islanders, including, quote, actions and opinions of yourself, contestants, and other participants, which may or may not depict you in a positive light, and or which you may deem personal, surprising, embarrassing, offensive, or of an otherwise unfavorable nature. And according to the contract, that kind of editing is, quote, fundamental to the program. This means the producers can shape contestants' stories to maximize drama, even if that spin misrepresents personalities or highlights selective footage. And despite Kateb's reluctance to return to the series, she signed back up for Love Island Beyond the Villa. That takes us to rule number 3. You're only allowed 2 drinks per night. Now, reality shows often give their cast many opportunities to drink. I, of course, wouldn't know, but others have informed me that alcohol tends to loosen people up, making them more prone to outbursts and overall drama. This is, of course, great for reality TV producers, but a nightmare for lawyers.
I actually feel better. You're spilling your drink. You're spilling your drink. Well, calm down.
And that's why producers impose a 2-drink limit on Love Island USA and now Love Island UK. And this is all about risk mitigation. Numerous lawsuits have been filed against reality TV producers for encouraging contestants to get drunk. Love is Blind cast members, for instance, allege that producers withheld food and water, but encouraged them to get drunk on an empty stomach. Caroline Manzo from Real Housewives of New Jersey sued Bravo, alleging producers plied cast members with booze and then encouraged them to sexually harass each other because it's good for ratings. Oh, wait a minute. You're telling me that the Real Housewives cast members got drunk and disorderly?
And they walk out. She
out of her mind.
I'm shocked. But by limiting alcohol, Love Island producers can argue that they took reasonable precautions, which is very important if someone ends up suing. Of course, the 2-drink rule raises a lot of follow-up questions. Does the production make drinks available 24/7? Who's responsible for policing the 2-drink rule? The Islanders or the producers? Has the show ever kicked someone out for violating the excessive drinking rule? And most importantly, why in the world would anyone act like this while they're being filmed if they're not drunk?
You don't do that on the first night. I swear to God,
But generally those issues only come up if someone actually sues the show, which, as we'll talk about, might not actually be a possibility. But that takes us to rule number 4, your mental health and sexual history are fair game. Now, when casting for reality TV, producers have a difficult needle to thread. They need emotionally combustible people who will experience big emotions for the cameras, but they also don't want people who are too fragile or vulnerable for safety reasons and, most importantly, to limit liability. Unfortunately, several former Love Island cast members have discussed their mental health struggles, and 3 people from Love Island UK have died by suicide. Love Island contestant and former Miss Great Britain, Sophie Graden, died in 2018. Before her death, she described being bombarded with cruel messages about her appearance and behavior, especially after being the show's first bisexual contestant. After the CEO of ITV said it was strange to link Graden's death with her appearance on the show, Graden's mother slammed the series as, quote, principally evil. She wrote an open letter revealing that Graden had asked for mental health support, but Love Island only offered a 10-minute Skype session. In 2019, contestant Mike Thalassitis took his own life. Nicknamed Muggy Mike on the show, he became a target of tabloid mockery and online trolling. The press painted him as aggressive and arrogant, and after his appearance, he struggled to adjust to life outside the villa and reportedly faced financial issues and depression. His parents said the series didn't prepare him for sudden fame. And in 2020, the show's UK host, Caroline Flack, also died by suicide. Now, after these deaths, the UK Parliament initiated a full investigation of reality TV in Britain, and producers added a slew of new requirements to the casting process. Now, prospective cast members must undergo full medical and psychological screening, including random drug tests and disclosure of their complete psychological and sexual health history. And here's the form that the cast members must give their physicians, who must describe any mental or physical health treatment the person is undergoing. The physician then has to sign off on their patient's suitability for the show. Quote, do you foresee any physical, psychological, or any other reason not to take part in this program? And contestants are warned explicitly that Love Island, quote, will test you and put you under pressure in ways that you are unlikely to have faced before. UK regulators also imposed new aftercare requirements on reality TV. Love Island UK contestants receive at least 8 therapy sessions after their time on the show and commit to maintaining contact for 18 months following their departure. The show also expanded its pre-show training to include guidance on social media use, managing fame, and financial literacy. Welfare officers are now present 24/7 on set, and Islanders undergo daily mental health check-ins during filming. But that takes us to rule number 5, you give up your rights to your own image. Now, by signing up for Love Island, you agree to give the show ownership of your name, likeness, voice, and performance forever. The Love Island contract includes a sweeping IP assignment clause. It says, quote, you hereby assign to us absolutely the entire copyright throughout the universe by all means and in all media, whether now known or hereafter developed for the full period of copyright, all renewals, revivals, reversions, and extensions thereof, and thereafter in so far as possible in perpetuity and to the extent relevant by way of present assignment of future copyright, and all of the rights whatsoever, including those rights known as the rental right and the lending right of the performer's rights in perpetuity. Now, this sweeping IP assignment clause gives the producers of Love Island basically every right they could possibly want for now until the end of time. And this even includes application materials contestants submitted to get on the show. The bottom line is that once you appear on the show, producers can use your footage, name, and voice in future promos, spin-offs, and marketing campaigns. And you can't do anything about it. And that takes us to rule number 6. You get no phones, no internet, and no outside world. Love Island contestants agree to be totally cut off from the outside world.
Time is fake, the date is fake, you have no access to the outside world. You can't Google, you can't watch TV, you can't access your socials, you can't text anybody.
Contestants are not allowed to have access to the internet or to their personal devices. They aren't allowed to look at or post on their own social media accounts while they remain at the villa, and instead a team handles the social media accounts on their behalf. Now, the isolation serves 2 purposes. First, it makes sure that the drama that unfolds inside the villa is completely self-contained and not contaminated by any information about the outside world. And second, it ensures that there is information asymmetry between producers and cast. In a world where the producers know everything and the Islanders know nothing, it's easier for the producers to engineer storyline.
You go a little crazy because, like, I think my phone set the same date every day. It's some dystopian society in there.
Which is similar to rule number 7, your social media isn't really yours and you better not talk. By agreeing to appear on Love Island, you cede control of your social media to the show. Quote, you also agree that we shall be entitled to use and incorporate into the program any relevant social media activity created by you, which shall include, without limitation, any Twitter posts, any Instagram posts, and or any other social media posts created by you on such other social media platforms now in existence or hereafter invented, the social media content. You hereby grant us the right to use all or part of any personal material and or social media content and exploit the same as part of the program to the fullest possible extent without any fees or monies becoming due to you or any third party. So anything you've done on social media before can be used on the show without any remuneration. And you also cannot talk about anything on social media or elsewhere without their permission. Quote, you warrant that all posts, blogs, tweets, messages, or other material you may publish on social networking sites such as Twitter, Facebook, Instagram, and any similar sites about your involvement in the program must comply with the Love Island social media guidelines, as well as the confidentiality clauses set out in Clause 10 of this agreement. You undertake to seek our advice if you are in any doubt as to whether or not to sub-publish such material. Now, the confidentiality provision in Clause 10 binds Islanders well beyond their time in the villa. Quote, you will not, without our prior written consent, either prior, during, or after the end of your contribution, use or knowingly divulge, publish, or make known directly or indirectly to any person or persons, media, multimedia outlet, or internet site, or interactive social media platform, including without limitation, Facebook and Twitter and such other social media sites existing or to be invented whatsoever, any information in connection with this agreement, the program, its production, and exploitation, your contribution, the products, any trade secrets, business plans, etc., or feature wholly or in part derived from or based on any material used or owned by us or any of our parent, subsidiary, or associated companies, or our or their customers at any time during the continuance of this engagement. Now, the contract is silent about what penalties apply if a person violates the confidentiality agreement. But reality TV producers have sued cast members for violating their NDAs. For example, Love is Blind cast member Renee Posh had agreed to marry Carter Wall before they were permitted to see each other. That's the conceit of the show. Couples get to know each other and become engaged before meeting in person. After the reveal, she found out that he was not a good guy to marry. He was a heavy drinker who couldn't pay his bills and appeared to be homeless. And she alleged that she felt threatened by him. But when she spoke out about her experience, producers sued her for $4 million for breaking her NDA. Which takes us to rule number 8. You don't get to choose where or even who you sleep with. On Love Island, where you sleep isn't really a matter of personal preference. Couples are expected to share a bed, and all the beds are crowded together in one big room.
I'm not being funny, but this is still my bed, so...
Oh no, I was just saying hello!
I literally can't even believe what I'm seeing.
And producers have an expectation that couples will share the same bed while together. However, in 2019, a US producer said there was some wiggle room. Quote, that is how the house is set up, but if somebody doesn't feel comfortable with that, or if a couple is having a spat, then they don't. But contestants also don't get to choose when they get to go to sleep or when they wake up. According to cast member Arabella Chai, producers won't let them go to bed early, and they all have the same call time in the morning. Which takes us to rule number 9, you have to follow a lot of other rules. The contract provides for a list of unacceptable behavior that can get you kicked out, including sexual advances that aren't returned, bullying, non-consensual touching, racist or homophobic language, distressing sexual conduct, or even behavior producers simply deem inappropriate. And contestants are expected to bring complaints directly to producers, who of course retain discretion over how and whether to act. But that takes us to the Mac Daddy of all of the laws of Love Island. You cannot file a lawsuit. Seriously, you literally cannot. Now, the conditions on Love Island seem pretty extreme and difficult to handle, so you might assume that these shows deal with quite a few lawsuits. Well, actually, they don't. Reality contracts have ironclad arbitration clauses, which require the parties to resolve their disputes through an arbitration process rather than a lawsuit. And as we've discussed on this channel before, the Supreme Court has repeatedly affirmed the enforceability of arbitration clauses in contracts, emphasizing that under the Federal Arbitration Act, the parties must honor agreements to arbitrate unless a legal or equitable reason renders the clause invalid. Now, that being said, despite the bad reputation that arbitrations have, generally speaking, they can vindicate your rights every bit as much as a trial can, and sometimes they end up being much cheaper to litigate and happen much faster because of the way that our court system is backed up and the time it takes to litigate in state court. But that being said, one huge advantage for the producers is that what happens in arbitration is much easier to keep secret. But contestants who attempt to fight back sometimes argue that these arbitration clauses are unconscionable, which is a legal doctrine that permits a court to void a contract provision that's both procedurally and substantively unfair. But because arbitrations are usually a perfectly valid substitute for lawsuits in court, courts have rarely sided with the reality TV participants in arbitration challenges. For example, in Ledwell versus Ravenel, the Fourth Circuit held that even if the participant had little choice but to sign the contract, the arbitration clause was acceptable because the terms themselves were not shockingly unfair. Dawn Ledwell, who worked as a nanny for cast member Catherine Dennis, appeared on the TV show Southern Charm. She was allegedly assaulted by Dennis's ex, Thomas Ravenel, but the court concluded that the matter could proceed in arbitration. But there have been some exceptions. In Higgins versus Superior Court, a California court invalidated an arbitration clause in a contract signed by 5 recently orphaned teenagers who appeared on Extreme Makeover Home Edition. The siblings were living with the Leomedy family, who parlayed their kindness towards the orphans to get on Extreme Makeover. They got a new home, but a few weeks after the remodel, the family kicked out the Higgins siblings. They argued that the producers didn't tell them that the family could simply evict them whenever they wanted. They claimed the producers offered them a permanent place to live, and the court found both procedural and substantive unconscionability. But even this victory was limited. In a subsequent case on the merits, Higgins versus Disney/ABC, the court concluded that the waiver of tort claims in the same contract was not substantively unconscionable. I am totally addicted to the Pitt, and I can't wait for season 2. I just hope there is a season 2, because the estate of Michael Crichton filed a lawsuit against Warner Brothers, alleging that the TV show The Pitt is an unauthorized reboot of ER. Crichton's wife accuses producer John Wells and star Noah Wyle of being morally repugnant, peddling lies, and virtually erasing Crichton's historic contributions to TV and film. And Sherry Crichton saved the most vitriol for Wells, accusing him of being a plagiarist and betraying a 30-year friendship. But at the heart of the lawsuit is a frozen rights clause Crichton negotiated when he sold his original ER screenplay, which barred any future adaptations without his approval. The estate alleges that Wells, Wiley, and showrunner Scott Gamill deliberately concealed their reboot plans for 2 years as part of a plot to stop Crichton from getting his flowers. Now, obviously, there are going to be some similarities between shows that involve an emergency room, but the defendants argue that when an ER revival fell through, they created an entirely new show. So, did the defendants actually breach their contract, or is this just another case of Hollywood recycling ideas? And how much protection does copyright law really offer when it comes to stock settings like a hospital drama? Now, as you probably know, The Pitt is a medical drama series streaming on HBO, which I refuse to call Max, that offers a realistic portrayal of the challenges faced by healthcare workers in a modern-day Pittsburgh hospital. The show centers on Dr. Michael Robbie Rabinovich, played by Noah Wyle, a senior attending physician, grappling with the emotional aftermath of the COVID-19 pandemic. Each of the 15 episodes represents an hour of a single intense 15-hour shift in the emergency room, giving viewers a bird's-eye view of the chaotic environment of frontline medical care. The series has been praised for its authenticity and depth, earning a 96% rating on Rotten Tomatoes and securing a second season renewal. And our friend Dr. Mike called it the most realistic hospital drama ever. And I am honestly totally addicted to it. I don't even know why. I don't understand half of the things that are going on, but it's really compelling television. And I guess now that it's not HBO, it is television. But let's talk about the drama behind the drama. In 1974, author and screenwriter Michael Crichton wrote a screenplay entitled Emergency Ward, which was eventually adapted into the hit medical drama ER. Crichton assigned the copyright in his screenplay to Warner Brothers in 1994. And as the lawsuit explains, quote, more than 15 years later, Crichton worked with Steven Spielberg to develop his creation into what became one of the most successful television series of all time. Running for 15 seasons on NBC and earning Crichton an Emmy Award as ER's creator and producer, just one of the 23 Emmys that the series won from among the 124 for which it was nominated. And as part of that original contract, Crichton and Warner Brothers included a frozen rights provision, which stated that, quote, any and all sequels, remakes, spin-offs, and or derivative works shall be frozen with mutual agreement between Crichton and Warner Brothers being necessary in order to move forward in any of these categories. So stick a pin in that because it's a pivotal issue for the breach of contract claim. And as we'll discuss, there's a reason why this is largely a contract claim and not a copyright claim, although the two are intertwined. But the suit says that Crichton made billions of dollars for NBC and made a career for Noah Wyle, whose character was based on Crichton himself.
John Carter.
Yes, sir.
Peter Benton. You the surgical student?
Yep, third year.
And the complaint claims that Crichton resuscitated Wells' career after a plagiarism scandal. Oscar-winning director Barry Levinson and writer David Simon accused Wells of stealing entire passages from Simon's book, Homicide: A Year on the Killing Streets, and using them in the TV series Angel Street. Wells settled that claim, and the show was canceled after 4 episodes. Now, Crichton passed away in 2008, so his widow, Sherry, has control over his estate, and she has a reputation for pugnaciously guarding his copyrights. After Crichton died, the estate alleges that Warner Brothers started a, quote, disturbing pattern of failing to celebrate him, choosing instead to betray his trust and diminish, and ultimately erase, Crichton entirely from his creations. And the complaint outlines some of the estate's grievances, quote, the pattern began with Westworld, the HBO series based on the 1973 film of the same name that Crichton had created, written, and directed. In lieu of the created by credit that Crichton deserved, the studio relegated him to a based upon credit buried deep in the end credits. But that indignity pales in comparison to what WBTV and its cohorts are now attempting in connection with ER. Now, as we've covered many times on this channel, allegations and a complaint are a one-sided story, so you may want to take some of these allegations with a grain of salt. They are a story told by one party to be persuasive. These slights apparently continued when producers sought to reboot ER. Sherry Crichton said that Wells called her on Thanksgiving Day 2022 after not speaking with her for years. Wells wanted to reboot ER, and he informed her that there would be a big press release on deadline announcing its return in a matter of days. Crichton said that Wells lied to her about how the series had been planned, claiming it had come together virtually overnight, and she says this was treachery because Wells and Wiley had been planning the reboot since 2020. She alleges that Wells knew about the frozen rights and wanted to shut her out of the deal. WB-TV called Sherry in early December and offered her a deal for the ER reboot. And at the time, Warner's allegedly said it would, quote, respect the Crichton estate's rights of approval to move forward with any subsequent productions. Now, the estate argues that this meant Warner's intended to respect his frozen rights. When the estate contacted WB-TV to follow up, the studio balked at giving Crichton the created by credit, and the negotiations stalled. Once Sherry Crichton asserted the frozen rights, she says Wiley and Wells reached out to her in, quote, a shameless attempt to pull at her heartstrings. For example, in a January 27, 2023 email to Sherry, Wiley expressed that he was appalled at the examples of disrespect shown you, Michael, and the estate, including in connection with Westworld. Wiley told Sherry that I admire, respect, and back your fight to protect Crichton's legacy and authorship, and assured her that was my sole intention here, as my gratitude to Michael will be everlasting. Sherry sent Wiley an email thanking him for reaching out, but told him ultimately all this rests with Warner Brothers. Wells was apparently next up, telling Sherry that I don't know anything about Michael's name being virtually erased from Westworld, and I think it was despicable. However, Sherry notes that Wells could not keep his own ego in check and bragged to Sherry with respect to the money Crichton had made from ER. Frankly, I made that money for him. Now, that did not go over well with Sherry, who told Wells the proposal Warner Brothers made was below market and thus unacceptable. It also involved troubling self-dealing. Later, Wiley apparently emailed Sherry a chronology of events, which backfired because it fueled the estate's claims that the reboot had been in the works for 2 years before anyone notified Sherry. Quote, Wiley had first reached out to Wells all the way back in February 2020 with the idea for a limited series that would pick up where ER had left off. Like the original series, the reboot would show the continuing collapse of urban hospital care as the COVID-19 pandemic, drug abuse, and chronic homelessness eroded the public health system. Wiley would reprise his role as a now seasoned physician, and the show would follow him through a 14-hour shift, during which he overcomes disillusionment with the system and recommits to his profession. The following year, Gamel reached out to Wiley with his own idea for a Carter-centric reboot, and they continued their discussion with Wells, culminating in an expression of interest from NBCU in July 2022. After that, apparently the estate still reached a tentative deal with Wells' production company. Wells agreed to the created by credit for Crichton before the Writers Guild, backed by a $5 million personal guarantee from Wells in the event those efforts were unsuccessful. However, apparently when WB-TV got back in the mix, the company allegedly yanked Wells' $5 million personal guarantee and the credit the estate wanted. That's when the estate invoked the frozen rights. But this time, Wiley, Wells, and WB-TV claimed that interest had plummeted in the ER reboot, and they moved on to create the Pitt. So the estate sued for breach of contract, interference with contractual relations, and breach of the covenants of good faith and fair dealing. So let's talk about the legal aspects of this whole case. As we've talked about many times on this channel, copyright in US law is a form of legal protection granted to the creators of original works of authorship, including literary, artistic, musical, and audiovisual works. And under the Copyright Act, copyright gives the creator exclusive rights to reproduce, distribute, perform, display, and create derivative works based on their original work. Now, these rights generally last for the author's lifetime, plus 70 years. But one of the major limitations on copyright is that copyright does not protect ideas, only their specific expression. Now, important here, derivative works are new creations based on a pre-existing copyrighted work, such as sequels, spin-offs, remakes, or adaptations in a different media, such as turning a screenplay into a film or a TV show into a video game. So for example, talking about Michael Crichton, Steven Spielberg had to get the rights to Jurassic Park from Michael Crichton in order to make a movie based on the novel Jurassic Park. But if you want to make an original movie that's a spy thriller based on a secret agent, you can absolutely do so, but if you want to make a sequel to James Bond, then that would be considered a derivative work, and you would need to get permission. But frozen rights clauses in copyright agreements are contractual provisions that limit or restrict a copyright holder's ability to exploit certain rights, usually derivative works, without the consent of the original creator. In the context of a frozen rights clause, derivative works are often the main focus of restrictions because they represent the most valuable long-term commercial opportunities. Without a frozen rights provision, a studio is free to develop derivative works without the original creator's input or approval. However, when such a clause is in place, the creator and their heirs retain control over whether and how derivative works are made. Derivative works can include sequels, remakes, spin-offs, reboots, merchandising, video game adaptations, amusement parks. Basically, every iteration of Harry Potter, for example, is a derivative from the original novels. And the Crichton dispute is a great example of how much harder it is for a studio or rights holder to make a derivative work when the creator has frozen rights. Not every writer is in a position to demand control over derivative rights, and studios generally only cede these rights to writers or creators with significant bargaining power. So when Crichton sold the rights to Westworld in the 70s, he didn't have much bargaining power. He was a new author. But by 1994, he was a highly popular author, and NBC really wanted the screenplay. So Crichton had leverage and he knew what to do with it. But there's another angle to this dispute. The frozen rights only kick in if there is an actual derivative work. And the defendants argue that the Pitt is not a derivative work of ER at all. So the defendants responded contending that, quote, the lawsuit is an effort to prohibit lifelong artists, the acclaimed writers, producers, and actor named as defendants in this action from publishing their work. And as such, they filed a motion alleging the case should be dismissed because it was a violation of California's anti-SLAPP law. And as we've talked about many times, SLAPP lawsuit, a strategic lawsuit against public participation, is designed to silence or punish people for exercising their free speech or petition rights. And anti-SLAPP laws protect individuals from these abusive lawsuits. And in California, which has one of the nation's strongest anti-SLAPP laws, when a defendant believes they are being sued for protected speech or petition activity, they can file an anti-SLAPP motion and have their case dismissed early and recover attorney's fees. And the defendants in this case argue that the Crichton estate filed the lawsuit in order to stop their creative work from ever seeing the light of day. The defendants acknowledge that Crichton's contract with Warner's, quote, regarding ER says the parties cannot make derivative works of ER without his consent. In 2022, some of the defendants approached Ms. Crichton about the possibility of making a reboot of ER. But Ms. Crichton rejected multiple proposals on extremely generous terms, and when it became clear that a reasonable deal was impossible, defendants decided to move on from the potential project. The defendants accused Sherry Crichton of demanding many millions of dollars, quote, well above industry standard rates, and more than WB-TV was willing or able to pay for a series in its first year. After Sherry allegedly stuck to demands that the studio called exorbitant, the defendants say that they walked away from the series, and Scott, quote, Gamel then worked to create a new show. And here they are laying the groundwork to claim that even though they originally wanted to do an ER reboot, that this second show was something entirely different. Quote, still interested in returning to the medical genre, but unburdened by the constraints of an ER reboot, he felt he could do something new. His excitement about creating something distinct from ER colored nearly every decision made in developing The Pitt. And defendants say the new script dropped all the elements of the old ER TV show. They said, quote, The Pitt does not align with any of these definitions as it does not share plot points, characters, or settings with ER. Therefore, it cannot be classified as a sequel, remake, or spin-off. Quote, The Pitt is not a derivative work. It is a new show with different names, iconography, plot lines, characters, locations, pacing. That both shows are medical dramas set in an emergency room and some of the same parties worked on them is insufficient as a matter of law to make The Pitt derivative of ER. Similarities are unprotectable ideas or scenes of fare. And I think this is the heart of what makes this particular case so fascinating. The scenes of fare doctrine is a copyright principle that excludes certain elements of creative works from protection because they are standard, inevitable, or dictated by the subject matter. The term comes from the French meaning scenes that must be done. And under this doctrine, courts recognize that some elements in a work are so commonplace or necessary for a particular genre or theme that they can't be copyrighted. These elements include stock characters like a hard-boiled detective in a noir story, common settings like a saloon in a western, standard tropes like a hacker using a computer screen covered in code, and predictable sequences of events such as a police officer reading a suspect Miranda rights in a TV crime drama. And scenes of fare is really important because it prevents copyright holders from monopolizing basic building blocks of storytelling. Now, to be liable for copyright infringement, the courts look to whether two works are, quote, substantially similar.
Oh, that's not good. Let's go again. 300?
Substantial similarity is a term of art. You can't just say, oh, these two things are substantially similar. There's a whole framework to determine that standard.
Clear?
All compressions?
And courts employ a two-part framework to assess substantial similarity between works. There's the extrinsic and intrinsic tests. Now, the extrinsic test is an objective analysis that dissects specific expressive elements such as plot, themes, dialogue, mood, setting, pace, characters, and sequence of events. It focuses solely on protectable components, excluding ideas, historical facts, or genre conventions. Now, this is probably hard to visualize for non-copyright people, but when you're making comparison between two works of art, you have to filter out and not take into consideration the unprotectable elements. So for example, if someone claimed that one movie was a ripoff of James Bond, and you were comparing the two movies, you probably wouldn't be able to use the mere fact that both main characters were secret agents, or used a handgun with a silencer on it. However, you probably would be able to use the fact that both characters, if this was the case, ordered a martini shaken, not stirred. The former are genre conventions or scenes of fare that are so ubiquitous that it would be unfair to make them protectable elements. But the latter is specific and creative enough expression that probably would be evidence in a copyright infringement case. So if a plaintiff's work fails to meet the extrinsic test, the case must be dismissed without proceeding to the intrinsic test. Now, the intrinsic test, on the other hand, is a subjective evaluation that considers whether an ordinary reasonable audience would perceive the total concept and feel of the two works as substantially similar. And that assessment is typically reserved for the jury. Now, the war over the film The Last Samurai, which starred Tom Cruise, is probably instructive here. In that case, screenwriters Aaron and Matthew Benet alleged that the Warner Brothers film The Last Samurai infringed upon their screenplay of the same name. Applying the extrinsic test, the Ninth Circuit Court determined that the similarities between the two works were primarily based on unprotectable elements. The court said, quote, "A number of similarities between the works arise out of the fact that both works are based on the same historical events, take place at the same time and in the same country, and share similar themes. These similarities are largely between unprotected elements, historical facts, characteristics that flow naturally from their shared premise, and scenes affaire." The Benets contended that they had submitted their screenplay to Warner's, and therefore the studio must have reviewed it and incorporated elements of the screenplay into the film. And you can imagine the screenwriters coming to the conclusion that a studio committed copyright infringement when they submitted a screenplay to that studio about an American who became a samurai in feudal Japan, and the studio released a movie about an American that became a samurai in feudal Japan. But the ruling emphasized that mere access to a work does not substantiate claims of unauthorized use. There must be clear proof of substantial similarities in protectable elements between the two works. The court concluded that the works were not substantially similar in their protectable aspects and upheld the summary judgment in favor of Warner Brothers. But all was not lost for the Benet screenwriters. While they lost their copyright claim, they did eventually prevail on some of their contract claims against the studio. And here, in the case of ER versus the Pitt, the plaintiffs and defendants have very different viewpoints about whether the Pitt is a knockoff of ER. The estate says that, quote, "The Pitt is ER. It's not like ER. It's not kind of ER. It's not sort of ER. It is ER, complete with the same executive producer, writer, star, production company, studio, and network as the planned ER reboot. No one has been fooled. The Hollywood Reporter recognized the reboot, now named The Pitt, for what it actually is, ER 2.0. And the defendants could not disagree more. Quote, "Once you look past the generic elements of the genre, The Pitt is entirely different from ER, involving different names and iconography, different plots, different characters, including those played by Wiley, whose character in ER was a green resident, with different themes, a different setting, a different pace, and a different approach to music and lighting. ER was also bound by network restrictions on language and nudity. The Pitt is a streaming show uninhibited by such restrictions. But generally sharing a plot and themes doesn't make a creative work derivative.
You think you know what you're doing? Believe me, you don't."
But the estate claims that the pilot episodes of both shows are strikingly similar. Quote, "Both pilots begin in the early morning and take place over the course of a single day. Both series use act breaks, commonly referred to as commercial breaks, which in the case of The Pitt is highly unusual for a series airing on premium cable or a streaming platform that does not air commercials. The main character's co-worker, friend in both series is a roguish bad boy. Both pilots introduce characters who are students interns on their first day at the hospital and are not prepared for what they will experience.
Med student down.
Welcome to the Pit. Let's go save some lives."
Both pilots have hospital staff members with suicidal tendencies.
Excuse me, she's my patient. Miss Carlton, please. Please.
What are you doing here? Working. And if you jump on my shift, that's just rude, man.
And both pilots feature patients who are regulars in the emergency room to the point where the staff know their names. And this is a great example of how in copyright cases, often the war is won or lost by the level of abstraction that you convince the court to use. Do you really drill down into the very minute details, or do you take a more 10,000 foot view to blend commonalities together? Now, clearly, some of these similarities stem from the fact that these are common tropes. Harried medical students, roguish doctors, and patients who are frequent flyers. These might be tropes because they also might be common experiences in real-life hospital settings. But certainly at a higher level of abstraction, the concept of a drama set in an urban hospital is a general idea that's not protected by copyright law. And as Wells points out in a declaration in the case, many shows and TV take place in similar settings like City Hospital, St. Elsewhere, ER, Casualty, Chicago Med, Dr. Kildare, Grey's Anatomy, New Amsterdam, and The Good Doctor. And the defendants argue that while the pilots share some similarities, the overall structure of the two series is different. After the pilot, ER followed a traditional case of the week format. The Pitt follows the doctors, nurses, and patients over the course of a single 15-hour shift, more like the TV show 24. Though the estate alleges that the concept of the ER reboot included this element, the single shift. And the most fascinating part of this case might have to do with what we make of Noah Wiley and his character. According to the estate, quote, Wiley's character is Dr. John Carter from ER in all but name, only 30 years later and imbued with the experience and lessons learned during the 15-year run of the original series. Now, a lot of people probably can't look at Wiley playing an ER doctor without thinking about the Dr. John Carter character, who ended his time on that show as a disillusioned doctor. And he's somewhat delusioned with medicine in the Pit as well, although that's arguable. But it also probably isn't determinative. As defendants point out, Noah Wiley himself is not protectable. Quote, that Wiley is involved in both shows is irrelevant in the derivative analysis because the identity of the actors in a show is not protected by copyright. Actors often portray characters with the same profession. And they point out that Mark Harmon playing a doctor in St. Elsewhere and Chicago Hope. Omar Epps played a doctor in ER and House. Now the case is going forward. The Los Angeles Superior Court denied the defendant's anti-SLAPP motion. And in doing so, it first ruled that defendants had established that the claims are premised on the creation of a television show, which is a constitutionally protected exercise of free speech. Consequently, the burden shifted to the estate to establish a probability of success on the merits of its claims, all of which, quote, rely on the issue of whether the Pit is a derivative work or otherwise infringes the copyright of ER. And pointing to the timeline of the planned ER reboot, including failed negotiations between the parties, followed by the creation of the Pit, the court concluded that the estate had met its burden to demonstrate that its claims have at least minimal merit. The court also cited a declaration by the drafter of the 1994 agreement as sufficient to challenge the defendant's interpretation of the contractual definition of derivative works. And finally, the court held that it could not determine at this early stage of the litigation the key question of whether the Pit was derivative of ER or not. So it'll be interesting to see what happens here. There are good arguments on both sides. My take is that it seems clear the parties tried to do an actual ER reboot. I don't think anyone denies that. And if they had gone forward with that, defendants would have needed the Crichton State's permission to do so. They obviously tried to do that and couldn't finalize the deal. And once that happened, the creators had the right to move on and do another hospital show, as long as it wasn't derivative of ER. The fact that they tried and failed to do an ER reboot doesn't necessarily mean that the creative team can't ever set a show in an emergency room. And they may have been influenced by ER. It would be hard not to be when Wiley and Wells are involved. But what about other influences? The show was clearly influenced by 24, but it's not the same as that show, and the estate might have gotten over its skis and let their obsession with how much credit Crichton wasn't getting get in the way of a good business deal that would have made them money. Actually, everything they're talking about, vasospasm or not,
is useless.
Legally irrelevant.
And medically.
All right, guys, you saw the medical disaster that was the first part of this video over on Dr. Mike's channel. But now we're gonna go to trial, and it's gonna get worse.
They're gonna need a medical expert to fix up the disaster that has been.
Well, you wanna give us a summary of what we saw on your channel?
Yeah, so medically speaking, there was a car accident that they came across as Good Samaritans because they weren't working, and one of the passengers was ejected from the vehicle. They were able to find him in the forest.
He's bleeding from his radial artery.
Losing a lot of blood. They put a tourniquet on, stopped the bleed, but then noticed, I don't know if it was the same arm or a different arm, or hand was not getting enough circulation. They panicked and they amputated the hand, thinking that because there wasn't enough perfusion, it was causing ischemia and that it would further damage his life and limit his survival. But medically, none of that really makes sense because if you put a tourniquet on someone's arm, it's already not getting blood flow. No blood flow is coming back to the body from that arm, and that's the point of a tourniquet. So the tourniquet was working, and they decided to amputate someone's arm. Go figure. In the field, might I add.
Yeah, in the field, and
while the ambulance was coming.
This good doctor has definitely committed malpractice.
Bad doctor.
In a Good Samaritan situation, to encourage doctors and lay people to provide medical care, you are not bound by the normal negligence rules. Usually the doctors are only liable if they committed gross negligence or willful misconduct. And it remains to be seen whether they can overcome the standard for the Good Samaritan.
Dr. Murphy cannot be held liable for professional misconduct because Dr. Murphy was not acting in a professional capacity. He was a Good Samaritan.
You can be both a doctor and a Good Samaritan.
Right.
The law in California is written to protect both the lay people who render care and also doctors.
So he could be a good doctor and a Good Samaritan.
Yes, he wasn't a good doctor.
Yeah, he wasn't.
He might be a Good Samaritan, we'll see.
The position that the Good Samaritan exception stayed in effect even after the ambulance arrived.
Yes, because he didn't do the amputation in the ambulance. He was outside the ambulance.
He chose not to do the amputation in the ambulance.
To save your...
It doesn't matter. The standard that we're looking at is, rendering aid in the place where it's normally not provided. The place that they would render aid would normally be in a hospital, yeah. In an emergency room.
If he had no time.
The ambulance was right there.
Right there. What does that mean? Would it have been right there if he was 10 feet away, 100 feet, or a half a mile?
All interesting questions for another case. He was 5 feet away.
Outside is outside.
My thought is they're going after his medical malpractice insurance, saying that he was functioning as a doctor, so he needs to be held liable for medical malpractice based on his insurance. And she's saying you can't go after his medical malpractice. He's not a doctor in the forest.
Right, they are arguing liability, so it's not about the insurance per se. And in fact, if it were to go to trial in a few years, the jury wouldn't even know whether insurance was at play. If they were to establish that he was not acting as a doctor, then the medical malpractice wouldn't kick in.
Yeah, exactly.
and they wouldn't get paid out.
So this isn't medical malpractice then?
He's rendering aid as a doctor. Malpractice would still kick in.
It would still apply even though he's not acting as a doctor.
For the most part, I would imagine yes, again, unless it was intentional, in which case then medical malpractice usually doesn't apply for intentional torts.
Got it.
And if the care happens at the scene of an emergency.
Counsel is using a technical distinction that...
Counsel is using the law. Statutory interpretation rules require Your Honor to give effect, if possible, to every clause and word of a statute.
You assume when you're analyzing a statute that every word in the statute has to have some meaning. So if your interpretation basically writes out half of the statute, that's not a good interpretation, and the judge and the courts will assume that when the legislature passed a law, they intended all parts of it to mean something. But that's not what they're arguing over. They're just arguing over the definition of one of the terms, being at the scene or
near the ambulance.
Yeah, near in the ambulance. So that argument makes no sense. And why is this guy sitting down? They're still arguing.
If it may be any construction, which implies that the legislature... 2 more squeaks. 2 more squeaks. 2 more squeaks. 2 more squeaks.
You just stopped?
I lost my train of thought.
Wait, what?
She couldn't pick back up in like a few minutes?
Let's assume that happened and she physically wasn't able to keep talking. Yes. It wouldn't actually matter that much because oral argument is not that important. They have briefed this issue. The written briefing is in front of the judge, and the judge, and more likely the clerk, is going to read the briefing and make a decision based on the arguments that have been presented. In written form, you put all of your best arguments in the writing.
Paper,
You also wouldn't generally know, like at the time of the hearing, whether you won or lost. It would come out several days later at a minimum. Even if she had frozen, if it was a good argument, she would have won, regardless of what she had said.
You could win this motion.
I would have finished it.
I heard a squeak.
Oh.
I needed 2 more squeaks to complete the set.
They pulled the settlement offer. And the partners met. You're off the case.
Well, we don't even know the answer to the motion.
The assumption is that they lost the motion.
Okay.
That could be really bad, though. Let's assume it was a motion for summary judgment, because everyone agrees that where the care was rendered, whether it was in the ambulance or not in the ambulance. Theoretically, if the motion for summary judgment was denied on the basis that there is an issue of fact, it could eventually go to trial many years later. If it is an issue on the law, where the judge says, sorry, I just don't think that the Good Samaritan law applies in general, then they'd be precluded from making that argument at trial. Super, super bad, because that's really the only argument that they had.
Yep.
It would be weird that the partners had a meeting like this. It would be extremely weird that an associate is going to run this litigation in general who has 0 experience. So we're just sort of in uncharted territory in general.
You are a good researcher. You are a database that thinks. But you need to accept that you are not. And you are never going to be a good lawyer.
That's a really harsh thing to say. I mean, she really is screwing up this case, so that might be accurate. That being said, there are lawyers of all stripes. Not all lawyers go to court. Not all lawyers need to interact with clients. Yeah. Having a really good writer and researcher is a totally normal thing to want in your law firm.
Very valuable.
No, no, no. Joni is my lawyer. It is my case, my choice.
And your career that's riding on this.
Can a client choose to keep the lawyer despite the fact the firm wanting to remove the lawyer?
That's tough, especially in the context of insurance. I think we probably have a conflict of interest with the insurance appointed counsel, in which case you'd probably trigger the Cumas Counsel statute, and you'd probably be allowed to choose a different lawyer to then interact with the law firm.
She would have to probably leave that law firm and be an independent lawyer.
She could probably do that. The insurance company gets to choose who they work with. He could get independent counsel as Cumas counsel, but I don't think he would necessarily be able to demand a particular lawyer as lead counsel.
Fair.
Why didn't you fire her?
Because she threatened to sue us, arguing that firing her would be a violation of the Americans with Disabilities Act.
Was it?
I'm not sure. I don't think so.
I mean, you should know that as a lawyer who is being threatened to be sued. The Americans with Disabilities Act allows for accommodations to be made, but if you are not able to do the job, then you might not be able to function in that particular job, and you have to be able to actually do the job. So if they wanted to fire her, they probably could have done that.
Dr. Murphy wants you as first chair.
What does that mean?
It means that she's running the trial. Usually the first chair would be the one who's giving the opening statement, the closing argument, and probably taking most of the examinations, but you might have a really large trial team where you're dividing up the labor, and at any given time, one other lawyer who's not first chair might be conducting an examination or giving a statement.
In your expert opinion, when Dr. Murphy concluded that my client's hand was irreversibly damaged and needed to be amputated...
He was wrong. The lack of blood flow was caused by a temporary condition known as vasospasm.
So this guy appears to be an expert witness, some doctor who they hired to give an opinion about this particular case. When they said, oh, if you don't accept this settlement, then we're going to go to trial. The expert process is part of discovery. So they would have deposed this expert. They would have gotten all of his opinions in writing
beforehand.
Months, maybe years before they got to trial. So none of what they are talking about, or none of what he's talking about, would be a surprise to anyone. And on top of it, you would have an army of other experts refuting what he's saying.
Yeah, I mean, both experts are wrong. A YouTube expert is having to fact check the two court experts. Terrible.
Your witness.
Any last minute ideas? Anything we can challenge him on medically?
It wasn't vasospasm.
Anything we could prove?
No.
You don't come up with trial strategy in trial.
Yeah, they knew about this, you said.
All of this was known. And even if they didn't, they would have talked to experts who would have come up with, they would have red teamed this.
Yeah, where is the hand surgeon?
Yeah.
Why don't we have a hand surgeon testify?
Dr. Rutenberg, are you being paid by the plaintiff's attorney for your testimony today?
I am.
Then you can hardly consider yourself unbiased.
Those are like pathology slides of an artery.
So what we heard in the background while she was looking at those slides is the classic questioning of the expert. You're being paid by the plaintiffs here, so we can't trust your opinion, which is absolutely necessary. Like, you need to point out this is not an objective observer here.
But isn't that always the case?
Yeah, it's always the case. Some of the best expert opinions and the experts that are testifying will testify both for the plaintiffs and the defense.
Oh, wow, okay.
So they can say, sometimes I am called by the plaintiffs and sometimes I'm called by the defendants.
It's routine for experts to be paid. You're being paid.
And I admit
Excuse me.
Oh my God, hold on a second. I'm gonna make a prediction. Is she gonna say he has like Raynaud's or something? Something wild? No way.
Well, she shouldn't be saying anything at all.
Yeah.
Because the questioning is being done by the other attorney. It is insane that
while your
co-counsel is going to interrupt your questioning.
team.
The judge would have absolutely jumped on her and said, what are you doing? Like, your co-counsel is questioning this witness. Sit down and shut up.
Traumatic vasospasm doesn't occur in isolated vessels, but rather the entire affected limb, right?
Yes, of course.
Can you visually identify a damaged or occluded vessel versus one in vasospasm?
Yes.
So,
wouldn't this have been pre-submitted? Whatever she's doing right now, she's going to show him something?
I'm going to graciously assume that all of what she has
was pre-submitted.
was submitted in evidence.
this one.
Occluded. Vasospasm. Vasospasm. Occluded.
Not vasospasm.
No.
Objection, Your Honor. Is this testimony or the MCAT?
That was a good objection. Or is that rude?
You have to state your grounds for the objection.
What would have been his grounds? Objection. Relevance?
Yeah.
Is that fair?
Yes, he could have said that.
Okay.
He would have gotten slammed. Pretty highly relevant to demonstrate whether he's able to do it or not.
That was a pathology image of Mr. Patton's radial artery.
And you can't just get up in the middle of cross-examination and say, guys, the thing that I did was really important for these following reasons. And that's what closing argument is for.
Yeah.
And if his radial artery didn't vasospasm, then according to your expert testimony, his ulnar artery didn't either. Is that correct?
It's possible. But we'd only know for sure if Dr. Murphy had given the calcium channel blocker.
I'm so confused. I think they started writing this and then they got confused themselves. Now they're saying both the radial and ulnar artery were occluded for different reasons?
Yeah, one was ripped open.
Or was that a lie? Did he misdiagnose that?
That would not surprise me at this point.
We'd only know for sure if Dr. Murphy had given the calcium channel blocker.
This is a classic mistake that shows make all the time. It's not important whether they got the answer right or not. It's not important whether the thing was vasospasm or whatever they're claiming it to be.
Yeah.
The thing that's important is, did he do the thing that a regular doctor did or should have done?
Let's say it wasn't vasospasm, but he still did the wrong thing.
Yeah.
It doesn't matter because he did the wrong thing.
Yeah. What they should be talking about is, under the circumstances, the doctor gets to the scene, they're presented with this.
Yeah.
What would a normal, reasonable doctor do?
Yeah, exactly. And they would not amputate a hand.
No doctor would actually amputate.
All they should have asked this doctor was, if you see someone who is bleeding out from their radial artery and you have a tourniquet on, do you ever amputate their hand in the field?
Yeah.
And if he says, I would never do that, that's the end of the case.
Actually, everything they're talking about, vasospasm or not,
is useless.
Legally irrelevant.
And medically.
I'm going to establish that he's a dick.
Who's a dick?
The victim.
Dr. Murphy saved your life.
Is that a question?
Not really.
Is that an objection?
Yeah.
Maybe phrase that in the form of a legally valid objection there. This is why you only interact with a judge.
Yeah.
You should not be having colloquy between the attorneys.
Person sues a person who saved their life. Do you sue people who buy you Christmas presents you don't want, or only the weird ones you figure the jury won't like?
Objection, compound and argumentative?
Is that a good?
Those objections were accurate. You can get away with that. You can withdraw when your questions, but if you do that enough times, the judge, who friggin' hated this attorney for simply introducing herself with her name, is like, all right, well, let her cook.
I'm a victim here.
You were driving, right?
Yes?
Over the speed limit?
I'm not sure.
According to police analysis of your skid marks?
Does that matter?
No, it doesn't matter, but he should be objecting to relevance. Who was at fault for the accident is irrelevant to whether the doctor provided good care or not.
Yeah, exactly.
Is she suing you for...
2 more squeaks. 2 more squeaks.
Miss Stewart, I will hold you in contempt.
That's totally improper, obviously.
If Dr. Murphy...
And then she just gets to continue? What are you talking? Arguably, she just
Is that
assaulted.
assault? Yeah.
She assaulted opposing counsel. That's enough.
And she warned her.
Yeah.
This is bad.
Great.
person
It's
and
assault.
just driven on, you'd be dead, and his career wouldn't hang in the balance.
Objection calls for speculation?
Not a lot.
The objection is sustained. Miss Stewart, that stunt just cost you $5,000. You're lucky it's not assault.
What? Is that a thing?
Oh yeah, I mean,
you could find her a specific set of dollars?
Sure, absolutely.
What?
$5,000 would probably be a reasonable amount for civil contempt or civil sanctions. Given that she just witnessed assault, I mean, she's being pretty sanguine about things.
Given where you sit today, right now, do you think one of the things that you and Dr. Park did wrong was stopping?
No. Then Mr. Patton would be dead.
That's not the question.
And the amputation.
It's not a question if you should have stopped for the accident. It's
no one's arguing that.
Yeah, the problem isn't that like they ran him over in the street and then stopped. The problem is once they stopped,
what did they do?
Yeah, they provided horrible medical treatment.
Dr. Murphy, you're different. Tell me about yourself.
Objection, vague and irrelevant.
Your challenges, the obstacles you've overcome.
Marginally less vague, still completely irrelevant.
And yet I will allow.
Oh!
Classic.
Why did
Classic
she
joke.
allow?
Unclear. I mean, vague, who cares? You wouldn't make that objection. Relevance, probably. The judge should not be really allowing it, at least in the context that they are getting at it.
Autism spectrum disorder. I have always had autism spectrum disorder. I have also always...
The cross would be devastating.
Yeah. Like you said you made those 4 mistakes. How do you know that you didn't make others? If you're willing to make those mistakes, is there a chance that you made other mistakes? Like, it's just so easy.
Yeah, you're nailing exactly what you would want to go over in cross-examination. Isn't it true that you completely misremembered what happened at the scene?
My mentor told me that people don't like me, that I make them uncomfortable. She's right. And people don't like my client either.
Give a closing. Entire sections of the rules of evidence preclude you from making it all about the character of either the plaintiff or the defendant or
yourself
or the legal counsel. Like, your character is not at issue here. It's about the facts as presented.
What would you say as opposing counsel in this situation?
I would get up there and say, the defense want to make this about anything
But the
other
case.
than the things that are relevant. The only question before you is, would a reasonable doctor have done this? And you heard testimony that was completely unrebutted, that under no circumstances would a doctor who was coming home from dinner
amputate
in the field with a rusty saw when the ambulance was right there. Grossly negligent.
We're different. But we're all different. You've worn purple every day of this trial. I
What?
assume because you love it.
No, come on, you can't do that.
No,
You can't
absolutely
say no
not.
out, George.
You can't talk to an individual juror and make it about the clothes that they're wearing. Are you out of your friggin' mind?
Oh my God.
No.
And because you want it to be your thing, you've got...
I would find that highly offensive.
Yeah.
Like, yeah, I
And
like.
she's smiling at it.
I like the color purple, but that's not who I am as a person.
Yeah, that's not my thing.
Way to misread the situation.
Those mutton chops, they're great. They're fun. They make you you.
Do they? Excuse me, ma'am.
She's like a pickup artist now.
I'm more than a haircut. Why would you be so reductive?
But when we start to get judged based on our differences, it's not fun anymore.
You're judging people on their appearances.
And fair enough. This is a courtroom. You are literally here to judge my client. But please don't judge him based on the way that he talks.
Who is doing that? Why is she jumping to that conclusion?
Well, she's trying to character assassinate the plaintiff.
Opposing counsel said nothing about his ASD diagnosis.
Yeah, absolutely not.
They didn't say he did this for no reason because he has ASD. He said they shouldn't have done this.
Yeah.
Medically, it was inappropriate.
She wants to make it about him being different and get sympathy, so she's saying affirmatively.
Which is not the right way to go about it.
Yeah, no. I mean,
Not even morally, it's not the right way to go about it.
I mean, legally, it's not the right way to do it either.
Or on how he doesn't look at you. Or on his awkward mannerisms. Judge
He was looking directly at them
Yeah,
when she
exactly.
said that.
him on who he is.
No. I even know it's not about that.
You judge him based on what he did and didn't do. That's the only relevant question here.
At every moment of his life, he has tried to make a difference, tried to make things a little better.
Yeah, except that one night on
Please
the
don't
road.
punish him for that.
That's not the
That's
issue.
not what they're punishing him for.
Please, do what the plaintiff should have done. Say thank you.
No!
What?
Oh, man.
I would disbar her just off this one trial.
I mean, she hasn't done anything disbarable except for not show up in court when she needed to. Maybe what has happened in this fictional world is that they lost the legal issue of Good Samaritan, so they're
bringing in
these
mental health.
stupid, unrelated things. We need a grade for medical realism here.
No. This cannot even warrant a grade. It's so bad. I mean, I guess the words they used were accurate, so it's a 1. Like they said words.
Yeah, I mean, similar to legal accuracy, they threw in some legal Mad Libs and got some of the things right. And basically,
That one objection you said he did.
Yeah,
okay,
there was one objection that was correct, and they did ask questions sometimes during the examination. So, I mean, I'm gonna go an F plus.
trip.
It's so bad. It's so bad.
I would give an F plus.
So F pluses all around. If you want to see something that's even worse, check out our last reaction to Grey's Anatomy.
Oh my God. You hashtag where's the sponge?
Hashtag where is the sponge? Here we had an extra hand. In that episode, we had an extra sponge.
Or a missing sponge. Or a missing hand.
Phantom sponge.
Phantom hand.
Check out that episode. Deploying the Marines. Doing third terms. This might be the most staggeringly corrupting that any president has. Open corruption is on Things have gotten worse. Things have gotten much, much worse. I wonder what my Audi's doing right now. If you create a person who only exists to work, do they have rights as we understand them? That's one of the many legal questions posed by Severance, a science fiction TV show on Apple TV, one that I happen to really like. In Severance, if you didn't know, and this isn't a spoiler, employees undergo a procedure that splits their work and personal memories into two separate two different people. When employees are at work for Lumen Industries, they know nothing about their lives or outside world. And when they clock out and go home, they don't retain any of the memories of what they did at work. Now, sometimes this might sound appealing. Say if you spent all day in a grueling occupation like coal mining or making videos about unprecedented legal problems, it might be nice to forget all of that by the time that you get home. Now, that technology doesn't quite exist yet, but the government already has approved experiments involving brain chips. And that means that some of the legal questions that Severance raises could be very real very soon. So today we're going to take a legal deep dive into the world of severed employees to answer the question, can you sign away your memories, your agency, and even your very sense of self, or do you still have legal rights? Now, in the show at the mysterious Lumen Industries, certain employees agree to undergo a procedure called severance, which surgically divides their memories between work and personal life. The result is two completely separate identities. The innie only exists inside of the office and knows nothing of the outside world, and the outie lives their normal life but has no memory of what happened at work. Mark Scout, played by Adam Scott, agrees to undergo severance to escape painful memories of his dead wife. And when Mark leaves work, he forgets all about his workday after he exits the elevator. Now, the show presumably takes place in an America that is similar to our own, but not identical. The technology is still analog, no one seems to have smartphones or tablets, and the America of the show seems to have gotten about as far as Microsoft Office 97, which featured Clippy. And believe it or not, that's Keanu Reeves voicing the anthropomorphized Lumen building.
I'm the Lumen Administrative Building, Branch 501.
But Lumen seems to be a corporation so powerful that it's overtaken most aspects of life. There is no reference to a government or laws, suggesting that there's been a blurring between the state and the corporation. And when the innies are at work, the company has complete control over them. We eventually learn that the founders of Lumen were quasi-religious figures, and the company is similar to a cult. Lumen has a charismatic founder named Kier, and moral commandments the employees are supposed to follow.
Kier, chosen one, Kier.
Think Scientology if it merged with a mega company like Amazon. And we're just a couple of seasons away from learning that everything is a simulation. But Mark's innie version works on a small team in a department called Macro Data Refinement, where no one really understands what they're doing or why. And the show follows Mark's dual existence as strange things begin happening at Lumen. And without spoiling anything, there's a chain of events that leads Mark's innie to question everything about his reality, and his outie seemingly as well. So the show presents some fascinating issues of law for us to dig into, starting with whether someone can legally consent to being severed. Now, severance is a surgical procedure that involves implanting a device in a person's brain. Now, could a person, in our world, legally make a choice to modify their brain in this way? Well, the American legal system recognizes some degree of bodily autonomy, although the parameters of those rights are perpetually in flux. For example, you have the right to consent to medical treatment or refuse it, and it's generally legal for adults to have elective surgery. On the other hand, the government can make some medical procedures illegal. In this year of our Lord 2025, like abortion or gender-affirming surgeries, or condition them on qualifiers like psychological evaluations or waiting periods. So we should probably assume that lawmakers, even in the Severance universe, would have the authority to outlaw procedures which modify the human brain. Since Severance requires the implantation of a special device in the brain, its legality turns on the regulation of brain implants, which are also referred to as neural chips. Now, the implantation of medical devices is governed by a complex web of regulations spearheaded by the Food and Drug Administration. The FDA categorizes all implantable devices by risk, with neural chips typically falling into Class 3, the highest risk category. That means they must undergo pre-market approval, which includes rigorous clinical testing and evidence demonstrating safety and effectiveness before they can be used or marketed. Class 3 devices include pacemakers, cochlear implants, deep brain stimulators, and even breast implants. Now, in certain cases, neural implants qualify for the FDA's investigational device exemption, which allows experimental devices to be implanted in humans during clinical trials. These trials must be approved and overseen by institutional review boards to ensure ethical standards are met, including fully informed consent from the patients. Now, as you might have heard, in 2023, the FDA denied Elon Musk's IDE application for his Neuralink device because his trial process didn't conform to those ethical standards. Later that same year, the FDA gave him the green light, and 3 people now have undergone a Neuralink procedure. And maybe that's the future of Tesla. Workers will consent to having a chip implanted in their brains that makes it so that when they go home, they don't even know that they work for now one of the world's most hated companies. Now, although in the past, the FDA was cautious about the purpose of these devices, restricting them to cases where the patient has paralysis, we live in Robert Kennedy Jr.'s world now where almost anything goes. The FDA recently launched ELSA, not that Elsa, an AI tool that can supposedly streamline the drug approval process, and this might lead to devices gaining faster approval, institutional review boards be damned. So let's game this out. Hey Elsa, can I have Severance?
Sure, as long as you freely consent to the brain implant. Here's a form you can sign.
Awesome. All right, so let's assume that this procedure is legal with patient consent and FDA approval. So now we get to the second question, which is the really juicy one. Would the INI constitute a separate legal person? Severed employees have one body, but 2 distinct consciousnesses, two distinct personas, each with their own memories, perceptions, and wills. So could the INI claim legal rights independent of their outies? Well, the show dealt with this when Innie Helly tried to cut off her own fingers in an attempt to send a message to her outie that she wanted to be released from her severance.
Do I look like I'm fucking around right now? No, you do not.
Her outie sends back a video asserting dominance.
But you know what? Eventually we all have to accept reality. I am a person. You are not.
Now, by saying you are not a person, you can't resign from Lumen, Helly is basically telling her Innie that she is not a legal person with rights. Eventually, Innie Helly attempts suicide as her only form of protest against Lumen and her outside self. But Lumen revives her and immediately forces her back to work. Now, under modern interpretations of substantive due process, this level of cognitive autonomy could support an argument for separate legal personhood. The foundation of legal personhood in the United States begins with the 5th and 14th Amendments, which prohibit the government from depriving any person of life, liberty, or property without due process. Courts have interpreted person broadly, granting protections to undocumented immigrants, same-sex couples, and even corporations. So the question becomes, if a being thinks, feels, and resists, does it deserve rights? Well, the Supreme Court considered this question in the context of a woman on life support. In Cruzen versus Director of Mississippi Department of Health, the court said that the state had a significant interest in preserving human life and protecting vulnerable people. The court said that before granting a family's request to terminate a woman's life support, the state of Missouri could require clear and convincing evidence that she would have wanted to withdraw life-sustaining treatment. The Cruzen court explored the concept of surrogate decision-making for people who are unable to make their own decisions because they're unconscious. Now, the INI characters could use that precedent to argue that they have a fundamental right to bodily autonomy, and their outie could not overrule that right by proxy without some form of due process. They could also cite to the growing trend of recognizing fetal personhood in various states. Fetal personhood advocates argue that fetal life is human life, and because the Constitution protects the rights of persons, those protections should extend to the unborn. Now, in Roe v. Wade, the court had said the word person, as used in the 14th Amendment, does not include the unborn. However, more recently, the Dobbs v. Jackson Women's Health Organization decision overturned Roe v. Wade. This might have opened the door for states to pass laws conferring fetal personhood. Fetal personhood would give fetuses legal rights, even against the mother while she was pregnant. And if the state can overrule a mother's medical decisions before the fetus has a separate cognizable legal interest, then in theory, outies can't dictate what happens to their INI personas. Now, Mark's story illustrates how complex this question of personhood is in the world of the show. Now, very minor spoiler, in season 2, Mark's outie attempted to reverse the severance process by damaging the chip so that the 2 personas could be reintegrated. Now, I won't spoil the main plot point of why Outie Mark wanted to do this, but Outie Mark desperately needed his INI to do something for him, so he made videos pleading with INI Mark to help him end the severance process.
It's like both of us, like one person combined. Like my memories and yours, and my trauma and yours, but like, you know, the good stuff too. So whoever this new hybrid person is, it's like he'd be way more you than me.
And therein lies the problem, because by that point, Mark's innie had fallen in love with one of the other innies, and he did not want to reverse the severance. And if he were forced to undergo surgical reintegration, it could effectively end his life as he knows it. From innie Mark's perspective, helping reverse the severance procedure is tantamount to removing a feeding tube against his will. It's an act that would erase his autonomy, identity, and relationships, including his love for Helly R, effectively murdering the innie? ? Yeah, obviously there is an argument that if the innie is a fully legally recognized person, that ending the ability for the innie to come back would effectively be murder. But then there's the question of what happens if the outie never decides to go back to the severed floor, and thus the innie never comes out again. One could argue this is a form of homicide. There's definitely an argument. It really hinges on the concept of personhood, which, as we've talked about, is a huge part of the show, intentionally, and it's a huge part of criminal law. And what makes a person? Conventionally, in criminal law, the person and the body are largely synonymous, though there are edge cases. For example, someone in a persistent vegetative state. In most jurisdictions, pulling the plug on someone in a persistent vegetative state is not considered murder so long as certain medical requirements are met. The body is there, but the person really isn't there anymore. And without any future hope of consciousness, the body is just an empty vessel. And in the show, generally speaking, the outie has to affirmatively step into the elevator to become their innie. So in a way, you could argue that if the outie says, yeah, I'm not going to do that, the innie is essentially in a persistent vegetative state. So really, to go to the motherhood example, it's as if the innie hasn't been born, or to put it another way, the innie is born every time the outie steps into the elevator and goes to the severed floor, and simply does not exist until that affirmative action is taken. And so for all of these reasons, I think you'd have a really hard time making a case for some form of homicide to take action that results in the negation of the innie. So sorry for everyone that loves Mark S and Helly R. Okay, but not so fast, innie Mark. If I represented outie Mark, I would argue that the outie retains full legal personhood, while the innie is simply a state or function of that person, not a separate legal person.
Do I have a family?
You'll never know.
And I have no choice.
Well, every time you find yourself here, it's because you chose to come back.
Mark has a right to live his life in the way that he wants to. If that means he wants to spend all day unaware of the painful memories of his dead wife, that's his personal choice. And I would argue that if he made the personal choice never to go back to the innie floor where innie Mark, comes back to life, that's not murder, that's just a choice that he made, and as a repercussion of that, innie Mark never comes back into life again. And in defending his right to control his innie, outie Mark could cite to precedent from an unlikely source: criminal cases involving people who have dissociative identity disorder, or DID. Now, generally courts have held that a person with DID is still one legal person. So criminal or civil liability still attaches to the whole individual, even if one alter committed the act and another has no memory of it. Though in rare instances, a person's DID diagnosis has impacted the legal status and punishment of the guilty person. State versus Milligan was one of the first cases where the defendant raised DID as a defense. Billy Milligan was charged with kidnapping, rape, and robbery. Experts diagnosed Milligan with DID, then known as multiple personality disorder, and he claimed that 2 of his alternative personalities had committed the crimes. The perpetrators were Reagan, a violent Yugoslav man, and Adalana, a shy woman. The main personality, Billy, was allegedly unaware of the crimes. Now, the judge found that Billy was not guilty by reason of insanity, and the court accepted the premise that an alter could be legally distinct enough to negate the criminal intent of the host personality. As a result, Milligan spent years in mental institutions rather than prison, because as we've talked about a lot on this channel, if you're found guilty by reason of insanity doesn't mean you go free. It means that you'll be given psychological treatment, sometimes for much longer than you would have gone to prison for. However, the Milligan case happened in 1978, and since then the law and psychiatry have evolved significantly. So it would probably be more difficult for a court to find Milligan legally insane if he were tried in 2025. Today, a person pleading not guilty by reason of insanity must prove that they are unable to distinguish right from wrong or lack control over their actions due to their mental defect. But even when mental illness fragments a person's consciousness, the law still sees one legal person in almost every circumstance. So outie Mark's strongest legal argument would probably be that his innie is not a separate legal person, but a compartmentalized consciousness similar to an alter ego. This construct, like the second personality, was created through a procedure he lawfully chose. And because he voluntarily underwent severance, he retains the legal authority to revoke it, regardless of any Mark's resistance. But there's a complicating factor. Mark wants to end his severance and reintegrate. But Lumen needs Mark to complete his work assignments, and they refuse to let him go. So is Lumen violating the 13th Amendment's prohibition on forced labor? The answer might be yes. The continued confinement and compelled labor of Mark and his colleagues arguably falls within the 13th Amendment's broad prohibition on both slavery and involuntary servitude. Now, involuntary servitude covers not just physical bondage, but also coerced labor conditions, restrictions on personal liberty, and situations where a person can't leave the workplace without significant penalty. And there's a thin line between consent and coercion, especially when it comes to labor agreements. Modern cases about the 13th Amendment are typically about debt slavery or human trafficking. Debt slavery is a system where private employers compel people to work to pay off debt and are prohibited from leaving until the debt is fully repaid. This system flourished in the South after the Civil War. Employers or landowners would front workers their tools, housing, or wages in advance, and then manipulate accounts to ensure the debt was never fully paid off, no matter how long the person worked. And if the debt wasn't paid off, the workers couldn't leave. What looked like a contractual relationship was really involuntary servitude. The Supreme Court declared debt peonage unconstitutional in Bailey versus Alabama in 1911, and the court struck down an Alabama law that criminalized breach of contract. Quote, Bailey contracted to work on a farm for a year at $12 a month. He quit after a month and did not return $15 advanced to him. Under Alabama law, Bailey's act was criminal. He was convicted and sentenced to 136 days of hard labor under the Alabama peonage law. And the Supreme Court said, quote, the fact that the debtor contracted to perform the labor which he refused to perform does not make the law any less objectionable. So there's no legal contract that can force a person to work, even if the work has started with apparent consent. A person is always allowed to quit their job. And in the US, a breach of contract is never a criminal matter. It's always civil. But Lumen's severance system adopts some of the same coercive logic of debt peonage. The workers don't owe a debt to Lumen, but they signed a contract agreeing to the severance procedure. That procedure bifurcates the worker into two people, neither of whom have full knowledge of the situation, vitiating the meaning of informed consent. And once the Audi signs the consent form, Lumen has trapped them inside a job they cannot leave. And since the Audi retains no memory of what happens at work, the relationship between employer and worker is arguably inherently exploitative. And Lumen's actions might violate the 13th Amendment in another way. People who are trafficked are often forced to work through violence, fraud, threats, or manipulation. And their captors often seize their identity documents, making it difficult for them to escape. And this fits squarely within the definition of involuntary servitude under the 13th Amendment. Even if a trafficked person appears to comply, the presence of psychological coercion can render such compliance moot for the purposes of the 13th Amendment and the federal statutes outlawing human trafficking. But it didn't always work that way. Initially, the Supreme Court adopted a narrow definition of involuntary servitude that did not include psychological coercion. However, in reaction to the court's decisions on the matter, Congress amended the relevant federal criminal statutes to specifically include situations involving involuntary servitude by means of, quote, threats of serious harm, including psychological coercion. And we see how this works in the context of the show. When Lumen wants to mentally break a severed employee, it sends them to the appropriately named break room. In season 1, Helly is sent to the break room after resisting work protocols, and once there, Milchick forces her to read a pre-written apology over and over, word for word, until the system deems her apology sincere.
I read it 300 times yesterday.
259. Again, please. Now.
Forgive me for the harm I've caused this world. None may atone for my actions but me.
And this goes on seemingly for days. The kind of forced repetition in an enclosed environment is a mind control technique, and it's often deployed by cult leaders who use psychological manipulation and coercion to keep people from leaving. And since coercion doesn't have to come in the form of chains or physical threats in order to violate the 13th Amendment, then the Lumen workers have a strong case for involuntary servitude. They are confined to a workplace with no control over entering or exiting. They're forced to work on behalf of a corporation with no knowledge of the work that they are doing, and the benefits of their work flow entirely to the Audi selves and to the corporation. But Lumen is probably not without counterarguments. The company could say that they are not in control because they're just following the instructions of the Audis who consented to everything Lumen Industries does to them.
Thanks to Lumen, you never need to bring work home with you again.
But this counterargument also has its limits. Courts have held that a third party like an employer or family member can't consent on someone else's behalf to physical confinement, forced labor, or psychological harm, especially if the person experiencing it cannot revoke that consent. So what legal remedies, if any, would be available to the innies and the Audis? Well, Lumen employees have many potential tort claims against their employer. They could argue that they're held against their will in a confinement space with no reasonable means of escape, which is false imprisonment. Psychological torture in the break room could meet the standard for outrageous conduct, sufficient to qualify as intentional infliction of emotional distress. Helly's attempted suicide, Mark's panic attacks, and Dylan's outbursts support that this distress is severe and foreseeable. And there could be all kinds of medical malpractice claims, especially if Lumen misrepresented the effects of Severance. For example, when they chose Severance, they didn't realize how impactful the process would be and how it would create a dual self. For example, I can believe that Lumen disclosed that the innies wouldn't have the memories of their outies and outies wouldn't have the memories that are created by their innies, but I don't know that it necessarily follows that each innie would be a completely distinct personality from their outie. So I'd imagine the employees could sue under tort law for lack of informed consent. And if Lumen lied or omitted material facts about the severance procedure to the outies, that opens the door to fraudulent inducement claims. And this would probably cover situations where the employees were misled into thinking the process would be painless or reversible. And then there's battery, which is the intentional infliction of harmful or offensive bodily contact. Even if the employee technically consented, severance surgery may qualify as battery if the consent was uninformed or fraudulent. And based on everything Ms. Coble and Mr. Milchek did to gaslight, humiliate, and even injure the employees, Lumen could certainly be liable under employment law for creating a hostile work environment. So basically, if this was happening in the real world, it would spawn decades of litigation. Everybody's gonna get this part. But you know, this is Suits, so that's not surprising. Now, if you want to watch me lose my mind even more about this stupid show, there's an extended version of this video over on today's sponsor, Nebula. Okay, there's a Suits LA now. Let's see if it's any better than the original, or more likely much worse.
Getty, hey, look, I know you heard I changed my mind about testifying, but just let me explain. What is this?
The original arrest report on Tina.
He swore you wouldn't do that.
You swore that you would testify against Pellegrini.
Getty, she's just a kid.
Do you know where they'll send her? They will tear her to pieces in there.
But she doesn't have to go anywhere if you just do what you said you would.
Okay, so he's threatening this witness that if he doesn't testify, that he will arrest and presumably prosecute this guy's daughter. Now, apart from the legality and the ethics of doing that, this person would be absolutely torn apart on cross if the other side got a hold of this information. And you know, if they're doing their due diligence, they should have. They would basically get this guy on the stand and say, you didn't want to testify, but this prosecutor threatened that if you didn't, they would arrest your daughter. And you know, then that witness's testimony would look terrible.
Gotta go get a bite to eat. If I don't have word that you're gonna testify by the time I'm done, I will arrest your daughter.
Getty! I thought we were friends.
We are friends, Billy, which is why I'm risking my life for you. Now, get back inside before someone...
Oh, okay. So that guy exploded. Also, if you are friends with a witness, that is yet more fodder for cross-examination.
Love me like we're still young. Lady luck don't lead me young. Can we bring those good times back?
Okay, all right. So, not surprisingly, Suits LA takes place in LA. But interestingly, this is taking place at my old office. Assuming the building that they're showing as B-roll is actually where this is supposed to take place. This is in Century City, a part of Los Angeles. And there's a business complex here that includes the CAA building and then the Century Plaza Towers, which are very iconic because they're two towers and they are triangles. And I worked in both of the different triangle buildings and was there when the CAA building was being built. You'll also see that building, at least the lobby in Inception. A lot of really fancy law firms are in this place. So at least they got that part right so far.
Lester Thompson's just been arrested for murder.
Cancel my morning and get me that arrest report. I got every partner from M&A to divorce wanting to know what's going on with the merger, and Ted hasn't responded yet. Tell the partners I'll know if we're a go or not by tonight. And give me that crisis manager from last year. Once the press finds out, this is going to be O.J. Simpson all over again.
The old Suits rarely ever dealt with criminal law. And here we see, I think the main character was a former prosecutor, and then this guy is some sort of criminal defense lawyer. I guess his client has been accused of murder. Okay, so far so good, I suppose. So I guess Suits LA is going to be way more about criminal law than the original Suits ever was.
So you're the mighty Ted Black.
And you're Warner Brothers' newest action star. But they can't seem to find their checkbook.
We're just gonna dive right in?
Dylan, I took on the worst mobs in New York.
What?
I beat all of them. If I can do that to them, imagine what I can do for you.
But I need someone with confidence, and you just seem a little sheepish to me.
Dylan, you play a badass in the movies. I'm a badass in real life, and I intend to prove it to you right now.
Okay, all right. Ignore everything I just said. I guess Ted, the main character here, made a massive shift from being a criminal prosecutor to being an entertainment lawyer. He's representing an actress now. Wow. Okay. So that is not a common transition. Generally, the skills that make you a good prosecutor and a good criminal defense lawyer don't really translate to being an entertainment lawyer. I mean, sure, entertainment law gets into litigation, but wheeling and dealing with, studios and TV production companies, it's not the same thing. I doubt there are very many people, if any, in the country that went from being criminal prosecutors in New York to, within the span of a few years, becoming, top of their field entertainment transactional attorneys. That's insane.
We're gonna dance.
What's that?
The new deal I got you from Warner Brothers.
Got me? You don't represent me.
They're under the impression that I do, so why don't you take a look at the number?
Oh no! He doesn't even represent this actress, and he's holding himself out as her attorney. Now, putting aside whether he has the skills or the connections to do this kind of work at all, you absolutely cannot hold yourself out as someone's agent and representative when you're not. That is an incredible ethical lapse, which he's only doing solely for the purpose of showing off to this person who he wants to make a client, but she isn't his client at the moment. Good God.
How did you do this?
That's what I do.
Yes, I also want to know how you did this. Not practically, I know you just called someone up and negotiated this thing, but, figuratively, how dare you?
What happens tomorrow after your merger? You ever gonna have time for me again?
You told her?
Of course I did. We're open with our clients. You taught me that.
If we're so open, did you tell her that I haven't agreed to the merger yet?
Yes.
All right, so this law firm is going to negotiate some sort of merger. That's not terribly uncommon. Generally, firms want to merge with another firm where there's economy of scale or different practice groups complement each other, so they can go from, say having two small antitrust practices to having one giant antitrust practice. So I would assume that they're merging with another entertainment law firm, to be able to be, even more powerful and have a lot of people working on the same sort of stuff to be, more profitable, to, decrease costs and increase profits. That's why these firms merge.
Ted, I want...
Erica, we have been over this. Rick gets the bump.
Rick shines my shoes.
Okay, he's as good a lawyer as you, and he's a better manager.
I'm better in a room, and you know it.
And the day that matters, I will make you head of the department.
So we have two junior associates fighting over the head, I guess, of the entertainment division. Why isn't he the head? He's the entertainment guy, right? So why wouldn't he be the head of entertainment? I don't know why these two people are fighting about that. Also, the head of the entertainment division is going to be someone who has, every connection in Hollywood. It's not really, sadly, about being the best lawyer in this circumstance. It's, going to be the person that has, every studio head on speed dial and, can call somebody up. So why these people would be even in the contention for the head of the division in the first place, I have no idea.
I want to know why it was you who came down here and not Ted.
Because I handle criminal defense, whereas Ted handles your producing
I know
deals.
what Ted does.
Lester, let me explain something to you. They're saying a lot of very specific things happened last night.
What, that I killed my partner in my own backyard? Why would I do that?
All right, this guy has been accused of murder, and he's mad that his entertainment lawyer didn't come down to talk to him about defending him for attempted murder or attempted murder of some kind. That's a very easy conversation to have with a client. Hey, I don't do this kind of work. I work with someone who does do this work. You should work with them because they are the subject matter expert in criminal law. You don't want an entertainment lawyer, dealing with your criminal defense. This is a very weird disagreement to have.
You were celebrating your big opening. You start doing ecstasy and shooting into the hill. And all of a sudden, he shoots himself. That's what you're saying, right?
That is exactly what happened.
Lester, I know that you're scared, but go with self-defense. The odds of acquittal are 80%.
That's insane. Number one, self-defense rates are almost certainly not that high. Number two, this person has told you what their defense is, and it seems like a perfectly reasonable defense that he and his partner were getting high and shooting guns. Although, honestly, If you're shooting guns in the Hollywood Hills, it's not like it's the wilderness. There are going to be lots of people who are mad at you and, calling the cops. It's insane for him to just dismiss what this person is saying out of hand and saying, oh, you should fabricate a different story, which, by the way, is totally unethical and illegal to say that, oh, you should make up a different story that is false. That's suborning perjury. So yeah, I guess maybe it does make sense that he wanted Ted and not this criminal lawyer who has no idea what he's talking about.
This is about the promotion I told you, not before we merge.
And I told you that I've given my life to this firm.
And you want to be the fastest ever to be head of entertainment. I know.
Not everybody gets the toy that they want for their birthday.
This isn't a toy. I earned
Rick,
it.
you do not get to skip to the front of the goddamn line.
Again, it's very strange that the Ted guy is not the head of entertainment. It's weird that this guy is just kind of begging for being the head of entertainment. That it's not going to be up to one lawyer to make that decision. It's going to be a firm-wide, partner-wide decision. And generally speaking, like, the title doesn't really matter that much. It's the other way around. The people get the title that deserve it, and it would be very obvious, or nearly very obvious, who would be the head of the entertainment division. And it's not going to be just some random young person. It's such a weird way of creating drama here. Now, these lawyers are not very good, but if you do want a actual good lawyer, my law firm, the Eagle team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team.
I'm all in on the merger, and I want you to know why.
Come on, Ted, you don't have to.
We went at it pretty hard at the beginning of the negotiation, and I said some crappy things about criminal defense. This is how I want to make it up to you.
Hey, you apologized. Something you rarely do, so when you do it, it means everything.
Stuart, you said do.
Did I? What I meant to say is we're about to be the largest firm in the city.
You got that right.
They're about to be the largest firm in the city because of the merger. Okay, definitely not. I mean, unless they are taking up the entire building. There are some truly giant firms in Los Angeles. I mean, Los Angeles is the largest legal market in the United States. So every major firm in the country has a giant office in Los Angeles. And yeah, I mean, there are firms with probably between 500 and 1,000 lawyers in Los Angeles alone. And also, Ted was single-handedly holding up the merger. This firm can't be that big. Oh, also, so this firm is, I guess, mainly entertainment and crim law. What? I mean, there are certainly some firms with those practice areas, but the thing is, those two practice areas have like zero overlap. So you have very little economies of scale. It doesn't make a whole lot of sense to have a firm that's basically all crim law and all entertainment law, because the lawyers can't pinch hit from one side to the other. And also, your firm wouldn't be that big.
Lester?
I am not putting my life in that man's hands. You are taking my case. I don't want to hear another word about it.
You think because he wants you to plead self-defense, he thinks you did it?
Please, Ted, come on, man. I am begging you.
Stuart lives for this. He is the man for the job.
I cannot go with someone who doesn't believe me.
Yeah, no kidding. If you're accused of murder, you hire a criminal defense lawyer. You don't have your friggin' entertainment lawyer who, negotiated your contract with a movie studio to handle, this criminal law case.
I gotta swing back by the office.
Oh, come on, Ted. We haven't done this in forever. Let's go to Jones. One drink at the old hangout.
Depends. How much money you got?
Tens of dollars. Come on.
Yeah. Yes.
I like the relationship between these two guys. I mean, it's not strictly speaking legal, but if you're going to go into business with a partner, good that you get along personally with them. And I kind of like the banter between these two guys. It's fun.
Ted?
What's going on?
You better get in here. The entire 25th floor is gone.
It was Stuart, wasn't it? Who did we lose?
Every senior member of every department except sports and entertainment.
Okay, so they lost an entire floor of attorneys. And I guess it was the crim law guy who took everyone. Number one. So one floor of that building, that's a lot of lawyers. It does not make them anywhere near one of the largest firms in Los Angeles, not even close. And while it looks dramatic when everyone leaves, I mean, these things take place over time. But also, I wonder where they're going. That's weird, because they were going to merge with another big firm.
What is there to think about? We need to file an injunction.
If we do that, the entire town will know we're weak. We will be dead in a year.
What? Okay, I mean, so this is California, so non-competes are hard to enforce, but they are more likely to be enforced against people who have equity in a company. So almost all of the partners, at least the equity partners who have left, would probably be bound by non-competes. They would certainly be bound by non-solicitation agreements, so they would be prohibited from soliciting all of the junior associates to go with them and, you know, taking the clients with them. But the idea that a law firm would look weak if they go and litigate this and get an injunction in court, it's the opposite. You would look weak by allowing this to happen and not seeking a judicial remedy. That is so dumb.
I'm not losing my firm.
You did. You already lost your firm. Everybody left. What's happening here?
Where are you going?
To get Litvack, Johnson, and Riley back before the entire town knows they're gone.
Amanda, what are you doing here? I thought you left with Stuart.
Stuart left.
I'm sorry, do you work here?
I've been handling pro bono for the past 2 years.
Rick will catch you up. Today you're helping us close clients.
Sorry, can't do it. Have a thing.
You'll do it, or I will fire you on the spot.
I run an office here so that I can have a nice address and you can pretend you actually serve your community. I don't actually work for you, so you can't fire me.
I will give you $100,000.
I don't need your money. My family owns half of the apartments on the west side, so I happen to be worth an ungodly amount of money.
You don't dress like it.
Well, first of all, not a good interaction to have. There are firms that have a large pro bono practice, but it's totally discretionary. And the people who do the pro bono work still work for the actual equity partners of the law firm. So in a world where everyone left the firm, he absolutely could fire her. The last thing he needs right now is a loss leader in a pro bono practice. That's ridiculous.
Son of a bitch, you set me up to get me out of the office.
You said you were a lion and I was a flea in front of everyone.
It was a negotiating tactic to get more.
This firm would be nothing without me. We started with 2 pillars, entertainment law and criminal defense, and everything else came from there. But you think it all comes from you because you don't respect what I do. Well, we'll see who's more important, because you signed an agreement giving me the right to take everyone with me.
He signed? No. What do you mean he signed an agreement to let him take everyone with him? That's insane. But also, are they just going to the firm that they were going to merge with in the first place? What's with the cloak and dagger stuff if you're just going through with the merger that was already going to take place?
You know what I think of Litvack, Johnson, and Riley? If they ever left and started their own firm, it'd be called lazy, fat, and stupid. If I could fire them today, I would, but I need their clients. Those were your words 6 months ago. Well, now I need their clients, so go ahead, sue. You know what I think of Litvack, Johnson, and Riley? If they ever left and started their own firm, it'd be called lazy, fat, and stupid. If I could fire them today, I would, but I need their clients.
Ted, I don't know what to say.
You don't need to say anything. Get Johnson and Riley to get the clients on board and sign papers with us by the end of the day.
Okay.
That's really good casting. That guy looks like a law firm partner. Everybody else, actors. This guy looks like a real partner.
Look who put his big boy pants on.
I have a proposition for you. I need someone on the inside. Feed me information for 6 months, then I name you head of entertainment.
Well, who says I won't be head of entertainment over here?
That voice inside you that knows Ted will never promote you over Rick.
I mean, my God, that would be so unethical. I mean, I get it that they're trying to make the crim law guy seem and be incredibly unethical. He's only had a few lines, and everything that he's ever said during this entire episode is showing that he really needs to be disbarred because everything he's doing is illegal. Opening it up to someone who is still working at a firm trying to get inside information, horrible ethical lapse. Everybody's going to get disbarred. But, you know, this is Suits, so that's not surprising.
I don't care what happened. I just wasted 2 hours waiting for your ADA, so I will be calling for sanctions.
A lot of what has happened in this episode is sanctionable. Waiting 2 hours for a meeting, which I presume was not taking place in court, definitely not sanctionable conduct. Dick move, but it's a very silly thing for her to say.
What sort of cases do you primarily handle?
Mostly criminal defense.
Well, how do you do it? How do you live with yourself knowing that whoever it is guilty of whatever it is they're accused of doing?
Because everyone deserves someone to fight for them.
And also, some of them are not guilty, including that actor guy who says that his partner accidentally shot himself. It is incredibly naive for this presumably bigwig attorney to be up in arms about criminal defense. It is a totally normal practice. You are representing some people who have done bad things. Those people still deserve a defense, and the state has to prove their case. Some people are innocent, and some people are everywhere in between. And what's crazy is supposedly this guy who was a prosecutor, the first thing that he did, I guess when he made the switch to entertainment law, which again makes zero sense, was partner with a criminal defense lawyer. If he hates criminal defense lawyers so much, why would he partner with them for 12 years?
I need you to drop Stewart and hire me.
You kidding me? I begged you.
Okay.
And you said Stuart Lane lives for this. He's the better man for the job. You said he was the best criminal defense attorney in the country.
Did you believe me? Because if you didn't, then you think I'm better than him. And if you did, then I can convince anyone of anything, because there is nothing in this world Stuart Lane is better at than me. Lester, he doesn't believe you.
So, okay, well, first of all, whether the lawyer believes you or not, you have to go by what your client is saying, assuming it to be true. But also, it's not what these shows almost always get wrong is that it's not necessarily about skills as a litigator. That is important, although I'm not even sure that this guy is a litigator. He seems to be a transactional entertainment lawyer. Putting that aside for the moment, it's not just about the skills, being a trial lawyer. It is also the experience that you have and the knowledge that you have in the case law that is relevant. You need to know the specific procedure that applies only in certain subject areas. And you need to have the experience of going through things multiple different times, dealing with different situations in that universe of the legal world. Because if you're an entertainment lawyer, it means you're probably not a very good criminal defense lawyer.
It's the fourth quarter. You need a touchdown. You can go with Kirk Cousins or Patrick Mahomes. Who's it going to be?
But it's also very much not the fourth quarter. This guy was just accused of this murder. Nothing has happened in the criminal case yet. The investigation probably isn't even over yet. You absolutely don't need a Hail Mary at the end of the fourth quarter. The game has barely started at this point, and basically you just want a good criminal lawyer, not your entertainment lawyer.
I don't just want a title, I want to be partner.
That's a lot to ask.
What? Okay, so she finally got the title of head of entertainment, but she's not a partner in this firm. Is the other guy, is Rick not a partner as well? There is no universe in which any kind of mid-sized to large entertainment firm would make someone the head of entertainment and they wouldn't already be a partner. That's insane. Also, who cares about the title if you're not already a partner? Oh my God, I'm losing my mind. I'm losing my mind.
Mr. Lane, we're scheduled to arraign your client on Monday, so please explain to me why I made room to do it now.
Don't look at me, Your Honor. I didn't ask for this hearing.
Okay, first of all, that courtroom is absolutely not the criminal law courtroom where an arraignment would take place. I mean, that is the most Hollywood-looking courtroom I've ever seen in my entire life. The lighting is way too good, way too modern. That is not what courtrooms in Los Angeles look like. Also, the arraignment is going to take place on the judge's calendar. There's going to be like 200 people in that room, all needing to get arraigned, and the idea that the court is going to move up an arraignment at the request of the defense lawyer, totally ridiculous.
Well, then who the hell did?
That would be me, Your Honor. I also have a motion to substitute counsel.
Oh, okay. So he somehow moved up a motion while he wasn't the counsel of record. Also a thing that's not going to happen.
You know he can't stand doing this, right?
I know he believes me and you don't.
Mr. Lane.
If he wants it, he can have it, Your Honor.
All right then, Mr. Thompson. How do you plead?
My client pleads not guilty, Your Honor, because he didn't do it.
And the judge is like, cool, I don't care, not guilty. Let me move on to the next person.
You're both gonna regret this.
Lester won't, because I have never lost the case, and I'm sure as hell not gonna start now. You wanna spill my secrets? You remember, I have some of yours too.
I was diagnosed with a fear.
Okay, well, that was Suits LA. Now it's time to give it a grade for legal realism. man, well, this one's interesting because there's really no law in it for the most part. It's really just law firm intrigue and mergers and stuff, which in my mind is not the juiciest part of practicing law. Yeah, and when they do talk about law firm mergers, they get it wrong. It's totally unrealistic for a big firm in Los Angeles. And the little bit of law that they do is totally unethical at every single turn. And I don't even know why they call it Suits. They kind of took away everything about Suits that made it Suits in the first place. So I'm going to give Suits LA a D+ for legal realism.